3, 2, 1. The Judiciary Committee will please come to order, a quorum being present. Without objection, the chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. I would like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 1693, the Eliminating a Quantifiably Unjust Application of the Law Act or the Equal Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1693, to eliminate the disparity in sentencing for cocaine offenses and for other
Objection,
purposes.
the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.R. 1693, the Eliminating a Quantifiably Unjust Application of the Law Act or the Equal Act, would eliminate the unjust sentencing disparity between crack cocaine and powder cocaine offenses. This long overdue bipartisan legislation would also allow defendants who were previously convicted or sentenced for a federal offense involving crack cocaine to petition for a sentence reduction. In 1986, Congress passed the Anti-Drug Abuse Act, which created mandatory minimum penalties for drug offenses and introduced the 100-to-1 sentencing disparity between crack cocaine and powder cocaine offenses. This meant that a person who distributed 5 grams of crack cocaine received the same 5-year mandatory minimum sentence as a person who distributed 500 grams of powder cocaine. A person who distributed 50 grams of crack cocaine received the same 10-year mandatory minimum sentence as a person who distributed 5,000 grams of powder cocaine. It soon became evident that this sentencing disparity had also created a significant racial disparity. For 4 years after Congress passed the Anti-Drug Abuse Act, the average federal sentence for black defendants was 49% higher than the average for white defendants. In the ensuing decades, the Sentencing Commission and many members of the law enforcement community strongly and repeatedly criticized the 100-to-1 ratio and urged Congress to address the disparity. As early as 1995, the Sentencing Commission began urging Congress to rectify this unfairness. Besides the troubling racial disparities in sentencing, the Commission also expressed concern over the significant difference in punishment between street-level dealers of crack cocaine and the powder cocaine suppliers who sold the cocaine in the first instance. Unfortunately, Congress rejected the Commission's proposed amendment to the sentencing guidelines to equalize the penalties for crack and powder cocaine. From 1997 to 2007, the Commission continued to warn Congress about the unjustified ratio, noting that there is no legislative history that explains Congress's rationale for selecting the 100-to-1 drug quantity ratio for powder cocaine and crack offenses. It provided evidence for its findings that the penalties exaggerated the relative harmfulness of crack cocaine, swept too broadly, most often applied to lower-level offenders, and mostly impacted minorities. Congress, however, took no action, prompting the Commission to pass an amendment to the sentencing guidelines in 2007 as a partial and modest remedy to the urgent and compelling problems associated with the ratio. In doing so, the Commission unanimously and strongly urged Congress to take action on its recommendations and to provide a comprehensive solution. In 2010, Congress finally acted by passing the Fair Sentencing Act, which did not eliminate the disparity, which significantly reduced the disparity from 100-to-1 to 18-to-1. But the fair sentencing applied only to pending and future cases, leaving thousands of inmates without a path of petition for relief. The First Step Act of 2018 made the Fair Sentencing Act retroactive, providing a path of relief for some, but not all, individuals affected by the sentencing disparity. It is now past time to finish the job. The crack cocaine and powder cocaine disparity has greatly contributed to the rise of mass incarceration, devastated communities of color, and severely undermined public confidence in our criminal justice system. The Equal Act would finally equalize the treatment of powder cocaine and crack cocaine, two forms of the same drug, by eliminating the sentencing disparity. It would also provide a path to retroactive relief from a disparity that is not rooted in science, does not promote public safety, and fosters racial disparities. This bipartisan legislation represents an important step in our efforts to reform the criminal justice system. I commend Representative Jeffries for introducing this important legislation and for assembling a broad and bipartisan coalition of stakeholders in support of the bill, including the Department of Justice and advocacy groups that span the ideological spectrum. I urge all my colleagues to support this bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Since Congress passed the Anti-Drug Abuse Act of 1986, the Federal Criminal Code has contained harsher punishments for individuals convicted of or sentenced for federal crimes related to crack cocaine as compared to powder cocaine, as you said in your opening statement. The Anti-Drug Abuse Act of 1986 created a 100-to-1 sentencing disparity between these two substances. At a hearing on this issue just a few weeks ago, many on the other side of the aisle discussed the racial disparity that these mandatory minimum sentences have on communities of color. But we should remember how this disparity came into existence. The Anti-Drug Abuse Act of 1986 passed the Democrat-controlled House by a vote of 392 to 16. Among the Democrats voting for the act in 86 were then Representative Chuck Schumer, Dick Durbin, Charlie Rangel, Major Owens. In the Senate, the act passed 97 to 2, with then Senators Joe Biden, John Kerry, and Al Gore all voting in favor. In fact, then Senator Biden not only voted for the measure, he co-sponsored it and helped write it. In 2010, Congress passed the Fair Sentencing Act, which reduced the sentencing disparity between crack and powder cocaine from 100-to-1 to 18-to-1, so a step in the right direction. In 2018, Congress passed and President Trump signed the First Step Act, which made the Fair Sentencing Act retroactive. This law allowed anyone sentenced for federal drug offenses related to cocaine to move for a resentencing under the 2010 standard. The Equal Act would eliminate the federal sentencing disparity between crack and powder cocaine and allow someone previously convicted of an offense related to cocaine to move for resentencing. Mr. Chairman, I thank you and yield back and look forward to our discussion.
I now recognize the chair of the Subcommittee on Crime, Terrorism, and Homeland Security, the gentlelady from Texas, Ms. Jackson Lee, for her opening statement.
Good morning, and thank you so very much, Mr. Chairman, and to the ranking member. I am proud to support H.R. 1693, which will finally eliminate the sentencing disparity between crack cocaine and powder cocaine offenses and provide retroactive relief to the thousands of individuals who received harsh and unfair sentencing based on this disparities. If you were to take a journey through the prison systems of America, both state and federal, you would see the remnants of the failed war on drugs. Individuals who received 20 and 30 and 40-year sentences, mostly falling and burdening those in urban centers and, yes, rural centers. I've long championed the equalization of crack cocaine and powder cocaine offenses. Beginning in 2007, I introduced legislation, H.R. 295, that would have ended the disparity because we had learned the most of the assumptions on which the 100-to-1 ratio was based turned out to be unfounded. For example, science makes clear that powder cocaine and crack cocaine are two forms of the same drug, producing similar effects once they reach the brain. There is no scientific basis for treating crack cocaine more harshly than powder cocaine. We also learned that there is no greater danger to public safety from crack offenders than powder cocaine offenders, and that the 100-to-1 ratio overstated the relative harmfulness of the two forms of cocaine and diverted federal resources away from prosecuting the highest level traffickers. The unfounded assumption that led to the 100-to-1 sentencing disparity has damaged communities of color for generations. A higher percentage of Black Americans are convicted of crack cocaine versus powder cocaine offenses and receive significantly longer sentences for comparable offenses. I'm aware of a neighbor's brother was standing on a street corner, had crack cocaine, and was not only charged with that offense, but was charged with conspiracy and was sentenced to 25 years in his young life. The percentage of individuals serving unreasonably longer sentences because of the disparity are not mere statistics from the Sentencing Commission. This data reflects lost years for thousands of individuals and families. These individuals are fathers, mothers, sons, and daughters. They are William Underwood, Matthew Charles, and Cynthia Shank, who testified before the House and Senate Judiciary Committees about the devastating impact that the sentencing disparity and mandatory minimum laws have had on them, their families, and countless others who are similarly situated. The crack and powder cocaine sentencing disparity is another byproduct of our country's failed war on drugs and our punitive response to the crack cocaine crisis of the 1980s. Congress, along race-based myths and unfounded assumptions about crack cocaine to shape federal cocaine sentencing policy. Rather, they allowed race-based myths. But it is time for science, data, and evidence to reform it. Congress started that process in 2010 when it passed the Fair Sentencing Act and reduced the sentencing disparity to 18-1. The First Step Act of 2018 made the Fair Sentencing Act retroactive. But the crack and powder cocaine disparity persists even under the 18-1 ratio. In fiscal year 2019, nearly 81% of crack cocaine offenders were Black, while 27.4% of powder cocaine offenders were Black. In fiscal year 2020, 77.1% of crack cocaine offenders were Black, while 27.3% of powder cocaine offenders were Black. Since 2010, the gap between the average sentence imposed for crack and powder cocaine offenses have narrowed but not closed. And as the Supreme Court recently noted in Terry versus United States, the lowest level of crack cocaine offenders are still ineligible for relief despite Congress' passage of the First Step Act. Today, we can end this injustice by passing the Equal Act of 2021 and putting an end to the harmful impact of the crack and powder cocaine sentencing disparity. In doing so, we will also ensure that thousands of people who have lost years of their lives because of the failed policies of the war on drugs have the opportunity for resentencing. I thank our friend, Representative and Chairman Jeffries, for introducing this bipartisan and bicameral legislation with original co-sponsors of Representative Bobby Scott, Kelly Armstrong, and Don Bacon, and delighted for those of us on Judiciary, as well as myself, to be co-sponsors on this important legislation. I also thank Chairman Nadler for his leadership in bringing up this bill as part of our federal sentencing reform agenda that we will continue to press in the subcommittee of which I chair. I urge my colleagues to join the bipartisan support, and that means all of our colleagues on both sides of the aisle, for the Equal Act, which includes members of this committee, and to vote yes on H.R. 1693. Mr. Chairman, I yield back.
The gentlelady yields back. I now recognize the ranking member of the Crime Subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statement.
I thank the chairman. It's so important to remember the words of one of our witnesses from a hearing on this topic just a few weeks ago. At a hearing on this issue, many on the other side of the dais discussed the racial disparity that these mandatory minimum sentences have on communities of color. Mr. Malcolm noted how he'd, quote, been struck at how often people agree about what ought to be done, even if they disagree about why those measures are warranted, close quote. He urged us to, quote, focus on your areas of agreement and not let the perfect be the enemy of the good, close quote. I hope that's what happens here today. Whether you support the bill or oppose it, I hope we can have an honest debate, honest discussion. I was struck at that hearing just a couple of weeks ago that many members on the other side claimed that the crack powder disparity is rooted in racist ideology. The reason that was so striking to me is because President Biden, Speaker Pelosi, and Majority Leader Schumer, all here when that law was put into place, supported the underlying laws that the Equal Act would now amend. Are we to believe that Democrats put racists in 3 of the top 4 political positions in this country, as would be implied by the previous speaker's comments? Around the time these laws were being passed, Ebony magazine profiled Congressman Charlie Rangel. The magazine labeled Congressman Rangel as, quote, the frontline general in the war on drugs, close quote. Representative Rangel is quoted as saying, I don't know what's behind the lackadaisical attitudes towards drugs. But I do know that the American people have made it abundantly clear. They are outraged by the indifference of the U.S. government to this problem. A couple years after that article, Congressman Rangel stated, quote, "We should not allow people to be able to distribute this poison without the fear that maybe they might be arrested and put in jail," close quote. Nobody in this room believes Charlie Rangel was or is a racist. So as we go through this today, I hope that we have a meaningful substantive discussion rather than a discussion that imputes motivations that may be wildly inaccurate. I hope that cooler heads prevail. Mr. Chairman, thank you. I yield back.
Gentleman yields back without objection. All other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1693, offered by Mr. Nadler of New York. Strike all that follows after the enacting clause.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. This amendment adds the phrase of 2021 to the bill's short title, but it makes no substantive changes to the bill. I urge members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute?
I move to strike the last word.
For what purpose does the gentleman from New York, Mr. Jeffries, the sponsor of the bill, seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank the distinguished chairman for your leadership and for recognizing me today. We are here to mark up H.R. 1693, the Eliminating a Quantifiably Unjust Application of the Law Act, otherwise referred to as the Equal Act, which will finally eliminate the federal crack and powder cocaine sentencing disparity and provide retroactive relief to those who have already been convicted or sentenced. In 1986, Congress passed the Anti-Drug Abuse Act, which established a 100-to-1 disparity in sentencing for crack cocaine and powder cocaine. That means a 5-year mandatory prison sentence for distribution of 500 grams of powder cocaine, but only 5 grams of crack cocaine to trigger the same sentence. Of course, there's no policy justification for punishing crack cocaine offenses more harshly than the same offense involving powder cocaine. Indeed, there is no pharmacological difference, no chemical difference, no physical difference in how the body processes crack cocaine as compared to powder cocaine. But there was a difference in terms of its disparate impact on communities of color and low-income communities of every single race. In urban America, in rural America, small-town America, and in Appalachia. Now, according to the U.S. Sentencing Commission, in fiscal year 2020, 77.1% of crack cocaine trafficking offenses were Black, whereas most powder cocaine offenders ultimately convicted and prosecuted were either white or Hispanic. There's a significant economic cost as well to the sentencing disparity. A recent report from the Prison Policy Initiative found that our system of mass incarceration, fueled in part by unjust sentencing drug laws, cost the government and American families and the taxpayers at least $182 billion every year. Of course, the human and economic costs of these policies have not resulted in improved public safety, which was the rationale used to justify the original laws. That is why we have the support of right-of-center groups like the Major Cities Chiefs Association, the Association of Prosecuting Attorneys, as well as, notably, the National District Attorneys Association. Stakeholders who, of course, understand what's necessary to keep America safe and have dedicated their life to doing so. They recognize that this law has been unsuccessful, unjust, and uneconomical. Now, Congress has acted several times, led by the Judiciary Committee, to incrementally eliminate and address the sentencing disparity. In 2010, Congress passed the Bipartisan Fair Sentencing Act, led by former members Bobby Scott and Jim Sensenbrenner, which reduced the disparity from 100 to 1 to 18 to 1. And then, of course, the Bipartisan First Step Act of 2018, which former President Trump signed into law, made that change from 100 to 1 to 18 to 1 retroactive. Today, 35 years after the Anti-Drug Abuse Act was signed into law and 50 years after President Richard Nixon declared the beginning of the failed war on drugs, it's time for this Judiciary Committee to finish the job that we have started over a decade ago and end this discriminatory law once and for all. The bill has broad support from groups within the law enforcement community, civil rights community, faith community, medical community, progressives, conservatives, and all points in between. And I would like to thank them for their tireless advocacy. Mr. Chairman, I ask unanimous consent to enter into the record letters from these organizations and their statements of support.
Without objection.
I also want to thank the bipartisan co-sponsors of this legislation, Representatives Kelly Armstrong, Bobby Scott, and Don Bacon, for their partner in leadership. I want to thank the chair of the subcommittee, Representative Sheila Jackson-Lee, for her steadfast leadership in this area, as well as the Republican supporters of this legislation in the Senate, Senators Portman, Tillis, and Rand Paul, along with Senators Booker and Durbin on our side of the aisle. I appreciate your time and consideration and urge the committee to support this legislation, and I yield back.
The gentleman yields back. For what purpose does the gentleman from Texas, Mr. Gomer, seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman, and I'm grateful to Congressman Jeffries for bringing this bill. And just so there's clarity about why there is such a gross disparity, since I've been here in Congress, the issue came up of the great disparity, and there were comments made at the time that, this was a racist disparity. Dan Lundgren was here, and he was saying that he was here back in the 80s when that had passed, and that Republicans had been told, some of the white members, if you don't support, and Charlie Rangel was pushing, most of the Congressional Black Caucus was, but he said Rangel's pitch was, if you do not support this big disparity in punishing crack cocaine, then you must be against minority communities because crack cocaine is absolutely destroying black communities. And that, the Republicans didn't want to be seen as racist, so they voted for that big disparity. And I agree with my colleagues across the aisle now that there really was not appropriate to have that kind of disparity. As someone who has sentenced people for both powder and crack cocaine under state law, I don't see any reason there should be this kind of disparity. But I would also caution that we be careful about how the term racist is used, because that term enabled a bill to pass that actually was racist, not in the intention of anybody, including the Black Caucus that was pushing it, but in effect, it was very unfair in the way it ended up treating people who had crack cocaine as opposed to powder cocaine. So I'd made the comment previously that it would be great if we could have a bill that just fixed this gross disparity, even the 18-to-1, and I am grateful to Mr. Jeffries for doing exactly that. This was a very clean bill that did exactly what the gentleman had indicated it would, And that's why I am pleased to be a co-sponsor and very grateful that you've handled it this way.
Would the gentleman yield?
Certainly.
Well, the gentleman is exactly right. Charlie Rangel and other members of the Black Caucus did, back in the 1980s, say that this was racist. They were wrong then, and they have admitted since then that they
Yes.
were wrong. I don't think there's any single member of the Black Caucus, current or present, who doesn't think, hasn't admitted, if they were then here, that their mistake.
And reclaim my time. So I applaud this. This is the way we ought to be doing things. I like having one subject, one bill, and we agree this does need to be fixed. So thank the chairman for bringing this to committee for markup, and I'm very grateful for the way in which this was brought to the committee.
Will the gentleman yield?
Certainly.
I want to thank the distinguished gentleman from Texas. We had this conversation informally, you and Cedric Richmond, when he was a part of the committee, and we appreciate your support and your commitment to dealing with this issue. And I think the record is very clear. It was a bipartisan failure. And as Chairman...
But you did it, and you made it happen,
And
I'm
as-
grateful
and as-
for that.
Well,
And the record should reflect, you did exactly what you said you were going to do, and I'm very grateful for that.
thank you.
I yield back.
The gentleman yields back. For what purpose does the gentleman from Rhode Island, Mr. Cicilline, seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
I want to thank you, Mr. Chairman, for bringing this bill to the committee, and I want to thank my friend, Chairman Jeffries, for introducing this vital and overdue bipartisan and bicameral legislation. In 1986, Congress passed the Anti-Drug Abuse Act. This law unjustly drew a drastic distinction between crack cocaine and powder cocaine, the same drug, just in a different form. That distinction created a sentencing disparity of up to 100 to 1, meaning you needed 100 times the amount of powder cocaine than crack cocaine to get the same sentence. We cannot overlook that this difference, like many drug enforcement laws in our history, created a highly disproportionate impact on communities of color. And there was no evidence-based rationale for this disparity. After decades of advocates and experts fighting to change the sentencing disparity, Congress finally acted in 2010 with the Fair Sentencing Act, which changed the disparity from 100 to 1 to 18 to 1. The First Step Act of 2018 made that change retroactive. We finally took a step in the right direction, but that wasn't enough. Just because 18 is lower than 100 doesn't mean we made things fair. There is still a huge sentencing disparity between crack and powder cocaine-related offenses today. This vital legislation finally ends the discriminatory sentencing disparity between crack and powder cocaine. It also importantly allows for those currently serving sentences related to crack cocaine to petition to have their sentences appropriately reduced. Our prisons are overcrowded, and lives are hurt every day because of sentencing disparities and high sentencing minimums for nonviolent crimes in America. This is one step of the many we need to take to change this horrible cycle. I want to thank Chairman Jeffries for this important legislation. I'm proud to support it today, and I urge my colleagues to do the same. And with that, I yield back.
Gentleman yields back. For what purpose does the gentleman from California, Mr. Isis, seek recognition?
Strike the last word, Mr. Chairman.
Gentleman is recognized.
Mr. Chairman, I think today is an extremely important day for all of us who want to take away a talking point which is real, which is appropriately needs to be reduced. Like you, I was here when we reduced from the 100 to 1 to 18 to 1, recognizing an extremely addictive drug and one that still has an adverse effect on our community. But in fairness, if the debate continued to be about the disparity between crack and powder cocaine, then we're missing the point. The point is that the war on drugs is not over, and to the extent that some want to call it a failed war for purposes of reducing or eliminating the punishment and the real effort to stop the illicit use of these dangerous drugs, they miss the point. Moving it to a 1-to-1 ratio, I believe, is not decriminalizing, nor would I support it if it is. Crack cocaine, powder cocaine, the various opiates of all sorts, including the synthetics like fentanyl, continue to represent a threat to our society and, in fact, are to a great extent the cause of violence. Legalizing these drugs or decriminalizing them would not in any way, shape, or form make our streets safer, our communities more productive, or life better for the very people we speak about today. For that reason, the reason of wanting to make sure that people have a confidence that it is not about one group over the other, it is not about punishing one group based on their race or the location that they're likely to live in, but rather a recognition that these drugs are dangerous, these drugs need to be stopped, and people will be punished, but that punishment will be equal to the suburban, well-to-do powder user versus the urban crack user is a worthwhile effort. So just as we did a decade ago, it is time to send that message, the message that Congress takes the illicit use of these drugs seriously, but wants to make sure that people believe that the protection of the communities versus the punishment of those who break the law is equal under the law. I support this legislation, but again, I do not support this legislation because it decriminalizes or because it's going to make the sentences light. I support it because it's going to allow people to get off the subject of somehow the disparity and on the subject of the danger of cocaine, just as the danger of fentanyl and other drugs are real and continue to have a detrimental effect on our society. So I hope that as we quickly pass this legislation, move it to the President's desk, we will do so recognizing two things. One, that we are still engaged in what will be a struggle for all of our lives, which is to keep our children from being hooked on addictive drugs that diminish their ability to be productive. And two, that we are not here to say that people are racist because of what the law was. As some of the other speakers have said, many of the people who did this did so at a time of great strife in their communities. I served with Charlie Rangel, as many of us on the dais did. I know that, in fact, he was dealing with a community that was ravaged by crack cocaine, and that he was doing what he thought at the time was the best. If he were here today, I have no doubt he would be leading the charge for this very change, but not because he cares differently about his community, but because the time for the message has changed, but not the time to continue the struggle against illicit drugs that diminish the lives of people in our communities, whether the suburban, the rural, or the urban. And Mr. Chairman, I thank you for bringing this legislation in a timely fashion and yield back. Of course I'd yield.
Let me just quickly with your assessment of Mr. Rangel's advocacy. All of us knew him, and the chairman is right, but I do think it is important to take note that facts change, crises do not, but facts change, and I believe Mr. Rangel, a former U.S. attorney, assistant U.S. attorney, was trying to save lives, as well as the Congressional Black Caucus. We maintain that we are the conscience of the Congress as it relates to these issues. And I can truly say that is where his direction was. This is now done by the gentleman from New York. I think it's more than appropriate, but I think we should recognize the times of that particular moment as related to crack cocaine. We're now looking to equalize the issues and to treat drug addiction in a totally different way. I just conclude my remarks by saying we remember the war on drugs led by other persons, and we see that that did not work. And so here we're trying to do what is right in 2021. I thank you for allowing me to have the time. I yield
Thank
back.
the gentlelady and yield back.
The gentleman yields back. For what purpose does Ms. Scanlon seek recognition?
Mr. Chairman, I move to strike the last word.
The gentlelady is recognized.
The disparate sentencing between crack and powder cocaine is a harmful remnant of the war on drugs, and it's contributed to the mass incarceration we see across the country. I'm thankful that national leadership and this Congress have chosen to learn from history and correct the mistakes of the past. In this case, the discriminatory sentencing disparities in crack cocaine offenses, which turbocharged the rise in mass incarceration. We've made progress on this issue with the Fair Sentencing Act and the First Step Act in recent years, but today we can go further. 6 years ago, I had the privilege to participate in the Clemency 2014 project, a joint initiative of the White House, the Department of Justice, and a host of nonprofit organizations across the ideological spectrum, ranging from the Koch brothers to Families Against Mandatory Minimums. With that project, I joined private bar lawyers across the country in screening thousands of case files of nonviolent offenders who'd been subjected to these unfair mandatory minimums. We filed hundreds of clemency petitions, and I was so pleased to be part of an effort with my firm where we obtained clemency for 29 individuals. In representing those clients, the devastation of the drug epidemic became clear, as did the fact that that devastation was compounded by harsh sentences for nonviolent, low-level offenders. By representing these folks, by talking with them and their families, we saw how it had destroyed their lives, destroyed their families, destroyed their communities. So now is the time to fully fix, actually it's past time, to fully fix this unjustified disparity once and for all, especially for those still serving sentences based upon it. Importantly, this bill is retroactive and allows those harmed by this misguided policy to seek justice. Thank you, Mr. Chairman and Mr. Jeffries, for putting forth this critical legislation for our consideration today. I'm looking forward to voting to pass the Equal Act out of committee today and urge all of my colleagues to support the bill. I yield back.
The gentlelady yields back. For what purpose does Ms. Deming seek recognition?
Move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. As a former police chief, I joined the Major City Chiefs Association in their support of this bipartisan legislation, the Equal Act. While we as a nation have come a long way, I clearly understand that there is still much work to do, and I am honored that we are doing that work together on this day. I served 27 years as an enforcer of the law, and now I have the privilege of serving here with my colleagues in Congress, writing the laws. Accountability does matter, but regardless of our political affiliation, as legislators, we share the awesome responsibility to eliminate, modify, tweak any policy or practice that has a disparate impact on any group of people. I know as a former law enforcement officer and a social worker that drug addiction has devastated many communities and many families. And I look forward to, in the future, working together to invest more resources in the treatment of individuals suffering from this devastating disease. But we must address sentencing disparities. Many colleagues here today have already pointed out an individual convicted of an offense involving 5 grams of crack cocaine would face the same mandatory minimum sentence as an individual convicted of a crime involving 500 grams of powdered cocaine. We know that that is not right. I clearly hear the concerns of my brothers and sisters of the National Association of Police Organizations about violent crime. As a police chief, the reduction of violent crime was my #1 priority. But the disparities involving the mere possession of crack versus powdered cocaine must be addressed. 41 states have already eliminated the sentencing disparities at the state level. Protecting Americans continues to be my top priority. The rule of law and the proper application of the law clearly define who we are as a nation. We can and we must rise up to meet this moment. I urge my colleagues to let's unanimously support this legislation. I thank the gentleman from New York, and with that, Mr. Chairman, I yield back.
For what purpose, the gentlelady yields back. For what purpose does Mr. Biggs seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. My only purpose is to submit for the record a letter dated July 16, 2021 from National Association of Police Organizations, Inc.
Without objection.
Thank you. I yield back.
Gentleman yields back. For what purpose does Mr. Cohen seek recognition?
Strike the last word and maybe
Gentleman's
the last
recognized.
20 years. Thank you, Mr. Chairman. When I walked in today, I thought of Bill Murray, and I thought of it even more when I got here. For the first person I saw on entering Rayburn was Bob Goodlatte, the honorable, decent, good human being, Bob Goodlatte. And it was like Groundhog's Day, seeing Bob walk into the building. And then to come to committee where he used to chair and hear us discussing crack cocaine and who was racist and what is racist and the drug war on drugs is even more Groundhog's Day. This war on drugs is as much, and I would submit a greater failure than Afghanistan. If we can get out of Afghanistan, which we've done, which I think is the right thing to do, but is still going to be a detriment to the girls and the women of Afghanistan and probably to many of the people who helped us, because we're not going to be able to get them out, wait until the last minute to try to get them out, the people that helped us as interpreters, translators, aides, etc. We can get out of the war on drugs too. But it'll take a bipartisan effort. It'll take the president to work with us. And it doesn't mean legalizing everything, but it means seeing these things as social problems, as mental health and physical health issues. Sending somebody who's hooked on heroin or cocaine or some other drug of that nature to jail is a waste of time and an error. To get them help and treatment is the right thing to do. This bill is long overdue. I remember when Bobby Scott and we worked to get it to 18 to 1. Well, 18 to 1 was not as bad as 100, but it was still wrong. And that was 10 years ago, I think. What Congressman Jeffries is doing, and those of us who've co-sponsored are doing the right thing. But unfortunately, Congress is slow as molasses in getting things done right and getting up to date and getting over cultural lag. This is a cultural lag oasis. And this bill ends one of those cultural lags. But another is having marijuana scheduled as Schedule 1. We've been talking about that the entire 15 years I've been here and before. And that's just as insane and just as much of a cultural lag. Marijuana is not as dangerous as heroin and the other drugs of which it's associated. And we need to deschedule it and get it out of the federal jurisdiction. You know, there was just a sprinter, Miss Shari Richardson, who was America's top 100-meter contestant to be in the Olympics. Her mother died. She smoked some marijuana after her mother's death because she was depressed and aggrieved, and she was in Oregon, a state where it's legal. But she had it in her system because it stays in your system for give or take 20 days. And so the Olympic Committee said, no, she can't compete. A lifelong dream that she'd been working for years and years and years, and she's not allowed to go to Tokyo. Marijuana is not a performance-enhancing drug unless you're entered in the Coney Island hot dog eating contest on the 4th of July. To take her right to appear and her dream away from her is absurd, and this Congress should see that we don't have these problems in the future. We deschedule marijuana, we leave it up to the states. If she'd have got rip-roaring drunk on margaritas, Red Bull, or whatever else you drink out there these days, lagers, she'd have been fine, because it wouldn't have shown up in her system. If it had shown in her system, if she'd have been 0.20 alcohol, she still would have been allowed to run. But for marijuana that could have been 20 days ago, and just a puff or two, she's gone. So let's get real. The war on drugs is a total failure. Nancy Reagan was wrong. Everybody who followed her and the others who said just say no were wrong because that wasn't sufficient. Let's pass this bill and let's decriminalize marijuana and let's get our people to where they are not being afflicted by the cultural lag of the United States Congress. Thank you. I yield back the balance of my time.
Gentleman yield back. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1693, offered by Ms. Jackson Lee. Page 2, strike lines 10 through 18.
Amendment will be considered as read. The gentlelady is recognized to explain her amendment.
I thank the chairman. I move to strike the last word. This amendment, which focuses on H.R. 1693's retroactivity provision, makes technical but important changes to ensure that our courts have the ability and discretion to efficiently decide sentence reduction motions that are filed by or on behalf of individuals who have been sentenced to crack cocaine offenses. After we passed the Fair Sentencing Act and First Step Act, federal courts were immediately bogged down in litigation involving a range of technical and substantive issues about the legislation. This litigation led to circuit splits and considerable delay for individuals seeking relief. The amendment first clarifies that the Equal Act's retroactivity provision applies to individuals that, in fact, who were sentenced to specific federal offenses involving crack cocaine on or before the date of enactment. Second, it allows courts to decide and hold resentencing hearings without the requirement that the defendant be present. Rule 43 of the Federal Rules of Criminal Procedure requires a defendant's presence at sentencing hearings, but resentencing presents issues that are not generally implicated during the initial sentencing process. Specifically, defendants who are already serving sentences are often incarcerated at federal facilities in states that are far from the district in which they were sentenced. This means the U.S. Marshals would have to transport individuals for hearings in which relief may or may not be granted by the court. Depending on the location, this transport could take weeks, denying that particular incarcerated person their rights. By adding language that does not require the defendant's presence, we will eliminate the burden on the marshals and unnecessary litigation over a technical issue. This also allows individuals seeking resentencing to receive a timely adjudication of their motions. We've already made a commitment as we support the Equal Act that we've lived in an unfair system. As we proceed to retroactively deal with resentencing, let's make it so these incarcerated persons can get their just day, hopefully their fair day. Third, the amendment adds the First Step Act's language limiting the number of motions that can be made under the Equal Act. This promotes judicial economy without diminishing the ability for all affected by the crack cocaine disparity to be heard and resentenced by courts in a timely manner. Again, justice must prevail. Finally, the amendment makes clear that courts have the discretion to grant motions for a sentence reduction based on the factors raised in 18 U.S.C. Section 3553A. Sentencing courts are in the best position to decide sentences based on all of the factors before it. We must ensure that we maintain a court's judicial discretion and the mandate on courts to impose sentences that are sufficient but are fair, just, and not greater than necessary under the current law. I believe that this represents the sentiment of most of the members of this committee over the years. With that, I ask my colleagues to support this amendment, and I yield back.
Mr. Chairman.
For what purpose does the gentleman seek recognition?
Well, just strike the last word. I would just say I think the amendment makes sense and is a good amendment. And I think our side will support that and appreciate the gentlelady bringing it forward.
Thank you, Mr.
The
Ranking.
gentleman yields back, and I now recognize myself to speak in support of the Jackson Lee amendment. The amendment makes several important changes to the Equal Act that strengthen the underlying legislation. It clarifies the application of the Act's retroactivity provisions specifically for crack cocaine offenses. It also promotes judicial economy by not requiring defendants to be present at resentencing, by incorporating the First Step Act's limitation on successive motions, and by making clear that courts have discretion in deciding motions for resentencing relief. In making these changes, we will ensure that individuals affected by the unjust sentencing disparity have a clear pathway for relief, and that our judicial system is not overburdened as courts fully exercise their discretion to consider motions for thousands of individuals who have been waiting year after year for the relief provided by the Equal Act. I thank Chairwoman Lee for offering the amendment. I thank Mr. Jordan for supporting it, and I urge my colleagues to support it as well. I yield back. For what purpose does Mr. Raskin seek recognition?
I move to strike the last word, Mr. Chairman.
The gentleman is recognized.
I rise in very strong favor of Mr. Jeffries' legislation, and I just want to salute him on the Equal Act, which eliminates that 18-to-1 sentencing disparity between powder cocaine and crack cocaine offenses, which itself, of course, was an improvement over the 100-to-1 sentencing disparity embodied in the 1986 Anti-Drug Abuse Act. And it's especially gratifying to see, such broad bipartisan support across the aisle for doing this. And I just wanted to take a moment to observe that we are all recognizing that this is an unjust disparity built into the law that has clear racially disproportionate effects, but it was not undertaken with any deliberate racist motive. All of which is to say that the law can operate in a way that adversely affects racial minority groups, even if the law is not adopted with a specific invidious purpose of discriminating against them. So it's a good teaching and learning moment for all of us, and I'm glad that we're moving forward to make the law much more equal and much more fair, regardless of where you stand on the underlying question of the war on drugs. And I yield back to you, Mr. Chairman.
The gentleman yields back. For what purpose does Ms. Dean seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
I too rise in support of the underlying legislation as well as the amendment offered by the gentlelady from Texas. This is a remarkable day. It's terrific to hear legislators recognizing the disparate impact, the unfair, unjust impact of former legislation. It's always the right time to correct what was a mistake of the past. This morning, I lend my unwavering support to the Equal Act. I recognize the importance of speaking truth to power when we discuss both addiction and racist sentencing disparities that have cast a shadow on the United States since the beginning of the so-called war on drugs. During multiple hearings, I've spoken to the failure that the war on drugs in the United States has imposed and commend the committee, Chairman Nadler, you for bringing up this important bill to markup. I echo the leadership of Representative Jeffries in highlighting the unjust sentencing disparities between crack cocaine and powder cocaine, a disparity not supported by criminal justice, not supported by science, and only supported by racial disparities that continue to be present within our criminal justice system. Our criminal justice system currently is not a one-size-fits-all system. For far too long, the United States has relied on a system of over-criminalization in which we overuse and misuse criminal law to address societal harms that could be more effectively handled through civil channels or other institutions. We have to deal with the issue of addiction and not simply criminalize it. This is evidenced by the nation's present incarcerated population, which sadly boasts of approximately 2.3 million people. This bill is an important first step to address the unjust war on drugs through its important retroactivity provisions made stronger by this amendment. I look forward to a future where drug addiction is addressed in a manner supported by science and health, decriminalization, and compassion for those who suffer from this disease. I urge my colleagues in this House to lend your support to the overdue bill, and I yield back the balance of my time, Mr. Chairman.
The gentlelady yields back. For what purpose? Oh, the question occurs on the Jackson-Lee amendment to the amendment in nature of a substitute. All in favor say aye. Aye. Opposed? The ayes obviously have it. Are there any further amendments to the amendment in the nature of a substitute?
Mr. Chair.
Who seeks recognition? For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chair, I have an amendment at the desk.
The point of order is reserved. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1693, offered by Mr. Fitzgerald of Wisconsin. Add at the end the following: D, fentanyl or fentanyl analog cases. Nothing in this section.
The amendment will be considered as read. The gentleman is recognized in support of his amendment.
Thank you, Mr. Chair. Good bill before us today, and good amendment that we just adopted. Has everything kind of moving in the right direction. I think I have something that I would hope that members of the committee would consider. I just returned from McAllen, Texas last week with Representative Biggs. And we had an opportunity not only to meet with Border Patrol and observe a lot of things that, quite honestly, were surprising to me or shocking to me, having not been to the border before in that context. But the one thing we heard from Homeland Security is kind of the methods they used or the approach they used to continue to catch most of the narcotics that they could, in fact, by design, come up with a strategy to capture, that are making their way across the border right now at an alarming rate. And there were some percentages thrown out. We're only 20% of maybe what's coming across is actually being apprehended. The major discussion was, again, and it's interesting to hear some of the comments, but a lot of it that was being captured was marijuana, cocaine, and fentanyl. Fentanyl. And so I know there was some discussion here about the war on drugs, but unfortunately, America's not fighting the war on drugs in a vacuum. There are so many other global influences on what's happening here. We know that the components of fentanyl are being manufactured in China, making their way to many different parts of South America. And then the fentanyl comes across. And there was a couple of anecdotal stories, but the one I just wanted to relay was there was a bachelor party where 4 guys were smoking pot, and unfortunately that pot was laced with fentanyl. And one of the individuals died, and 3 of them ended up in the hospital. So, what's being dismissed, I think, as, don't worry about it, it's just a few people smoking pot. That is not necessarily the case. The Mexican cartels, they continue to have full control over the production and supply of fentanyl into the U.S. And if you talk to law enforcement, they're going to tell you, this stuff is so deadly and so available. It's the new front that we need to fight on a regular basis. So the amendment I have before the committee today would simply, once again, incorporate the idea that fentanyl should be a Schedule I drug, and we're working on that with the SOFA Act, and we need to close any of these loopholes that I think currently exist. And like I said, good bill before us today, great bill, is going to tackle something that's very complex. And I think that Representative Jackson's amendment makes it better. And I think this also would not only, I think, do that. And if we were going to have a bill later on that was going to deal with the fentanyl issue, great, okay, let's do that. But, it's here. We're here this morning. We're tackling something that's bipartisan. We all know that this is a major issue. And I think that this amendment would make this bill much better. And who would oppose it once we get out of this committee? I mean, I can't believe that there would be anybody that would dismiss this as not necessary. If you talk to your local law enforcement, they're going to tell you it's here. It's not something that's coming. It's here on our doorstep. Let's do something about it right here this morning. Let's close this down. Let's give law enforcement the tools they need to fight this deadly drug that's now here in America. And I yield back. Thank you.
Gentleman yields back. Does the gentlelady insist on a point of order?
Mr. Chairman, I withdraw my point of order.
Point of order is withdrawn. The gentlelady withdraws a point of order. I recognize myself in opposition to the amendment. The amendment is clearly well-intended, but it is not necessary, and I am concerned that someone may read, that the amendment may be read incorrectly, but it may be read as limiting the application of the bill in a way that we wouldn't want it limited. So I would oppose it, although I really don't think and I don't think it's necessary. But it might be misread. So on those grounds, I would oppose it. I yield back. Does anyone else seek recognition on this amendment?
Mr. Chairman?
What
Move to
purpose
strike
is
the
it?
last word. Yeah, no, I appreciate the spirit in which the distinguished gentleman has offered this amendment, and certainly look forward to working with him on some of these issues and challenges related to fentanyl. I think as the distinguished gentleman from Texas, Mr. Gohmert, indicated, our objective here was to deal with this issue of the sentencing disparity involving crack cocaine and powder cocaine in the cleanest possible way. And it's for that reason that I oppose the amendment, but appreciate the spirit in which it has been offered.
Mr. Chairman.
Gentleman yields back. Does the gentleman yield back? Gentleman yields back. For what purpose does Mr. Jordan seek recognition?
Well, I strike the last word, Mr. Chairman. This is as simple as it gets. I mean, as the gentleman from Wisconsin it's a one-sentence amendment that says, we all know fentanyl is bad. Let's make sure we keep it that way and deal with it in the appropriate fashion. It's straightforward. If the chairman thinks I don't see where the chairman can think it's not necessary to state what we all know is obvious in a plain and straightforward amendment dealing with a substance that is wreaking havoc in so many of our communities in every one of our districts. So why not err on the side of making sure we deal with something in the best way possible, particularly a drug of this, a dangerous drug like this that has done so much harm to so many communities. With that, unless the gentleman from Wisconsin would like some time.
Would the gentleman yield?
I'd be happy to yield to the gentleman from Wisconsin, then I'll yield to the gentleman from Tennessee if there's time left.
Thank you to the ranking member. I mean, we know that, maybe we were in a territory where there was a question of germaneness. That's why we drafted an amendment to the amendment to kind of clear that up. I think we're really in good shape right now, and I can't understand why we wouldn't just simply take care of this right now. It makes no sense to me. I mean, I understand, people get kind of protective of their own piece of legislation and they don't want it amended and they don't want it maybe off the target, but I mean, this is all I heard about at the border was fentanyl and the deadliness of it and the effect it's having on this country. And like I said earlier, if there was a bill coming down the pike that dealt with just that issue, great. Let's take that up. But I'm unaware of that. And here it is before us this morning. Again, Mr. Chair, I'm not sure why we wouldn't tackle this right now. And I yield back to the ranking member.
Yield to the gentleman from Tennessee.
Thank you, Mr. Jordan. The question really is directed to anybody who can answer it. I don't see how this relates to the bill we've got before us. It changes crack and cocaine. It deals with crack and cocaine. I'm all against fentanyl, but this bill doesn't relate to fentanyl, and it doesn't change anything to do with fentanyl. It doesn't make the sentences less. As I see it, it doesn't change them. It has nothing to do with fentanyl. So if somebody can tell me why this fits, and if we do it, what difference it'll make in the world. I mean, I'm all against fentanyl. I'll be for all the anti-fentanyl, anti-heroin, anti-buggery, whatever bills you want to bring. But what has it got to do with this bill?
Well, I think the chairman already answered that question, said it was germane, and it deals with a very important issue that is confronting our country, confronting our nation, confronting every single neighborhood, and that's why the gentleman from Wisconsin brought his amendment forward. Be happy to yield to the gentleman from Ohio.
I thank gentlemen for yielding. I won't take a lot of time, but I thank the gentleman for offering this very constructive amendment, I believe. And this has been a pretty bipartisan markup here, and I think we're, for the most part, on the same side on this. We're trying to do what's fair here, and I think what's fair would be to include the gentleman's amendment in this. Fentanyl is killing thousands and thousands of Americans all across the country in all of our districts. I know it is in my district, and the thing that's so deadly about it is oftentimes people that, let's face it, shouldn't be ingesting or smoking or however they're taking the drugs to begin with, but some do. And many aren't aware that it's been laced with fentanyl, and there are analogs, and so the bad guys have been able to get around the traditional fentanyl by just modifying it in a slight manner molecularly, which makes it tough for the laws to actually apply in every case, makes it tough for prosecutors, and we've worked on that issue in a bipartisan manner for some time. But it's killing thousands and thousands of Americans, and I guess it would be more convenient just to ignore it altogether in this hearing. Why? Well, maybe because, for example, it's coming in from our greatest rival, China, and competitor, some would say enemy, but it's coming from there, and much of it is coming across a border which was pretty secure for quite some time because of the work of the previous administration and the Congress to some extent, which now is a tremendous crisis down, the Biden crisis at our southern border. It's coming across there and killing Americans, but I think if I had that record, I wouldn't want to talk about this either. So thank you to the gentleman for offering it. I yield back to the gentleman.
The gentleman's time has expired. For what purposes, Mr. Jackson, Lee seek recognition.
Mr. Chairman, thank you. I'd like to strike the last word. Let me associate myself with Mr. Chavitz's remarks that this legislation and this discussion has been enormously bipartisan, and I take the words of the ranking member seriously. I withdrew my objection. I think the gentleman from New York, the proponent of this legislation, has a very pointed remark. What I would say to you is that I think if we did a poll, I am assured that everyone would be opposed to fentanyl. It kills. So the chairman, ranking member, and to the proponent of the amendment, let's let our committee, our subcommittee is very interested in this issue. And I would make the argument that we could work together on the question of fentanyl in a more extensive way that would not, if you will, steer us away from the intent and mindset of the Equal Act. I think it's important for us to address fentanyl on its own two weak and wicked legs, and that is clearly what it is. It is a killer. And so I'd extend to the gentleman the opportunity to work together on focused legislation or focused opportunity to deal with fentanyl. We have not taken that up yet. We've had some other issues, of course, on our side of the aisle about increased mass incarceration, but we have no opposition for the deadliness of fentanyl. So I would indicate that I have an opposition to its present submission as an amendment, but to the ranking member, Mr. Jordan, and his point, Mr. Chavitz's point about bipartisanship on this legislation, I can say to you that we can work on this matter in our subcommittee and would be happy to work with the gentleman on that question at this time. With that, I will yield back my time or yield to the gentleman proponent. If not, I'll yield back.
Gentlelady yields back. So any further discussion of this amendment? For what purposes, Mr. Roy seek recognition?
Let's strike the last word.
The gentleman is recognized.
Thank the chairman. I certainly don't want to rain on the bipartisan parade. I'll have a little bit more to talk about in a minute about my concerns and disagreement with the underlying legislation. But with respect to the amendment, I do believe that the amendment has merit. I would recognize that it is, not directly on point with respect to cocaine specifically and the purpose of the underlying bill. However, given the extent to which fentanyl is, in fact, laced into numerous narcotics, notably cocaine, I do believe it's important to make that very clear that nothing would, negatively impact the ability of law enforcement to be able to go after those that are peddling, distributing fentanyl. And right now, we do, in fact, have a crisis of epic proportions relating to fentanyl. And I think it's, what we do as a body matters. What we do in terms of messaging matters. I think saying that whatever the result is of this debate on the crack powder disparity and what that means with respect to punishing those who peddle crack or cocaine, which I'll have more to say about in a minute, we should be very clear that the distribution of fentanyl, which is decimating our young and decimating thousands of Americans, directly as a consequence of wide open borders, which is literally not able to be refuted, right? It's factual, right? Why did Governor DeSantis send resources to Texas? In his speech, he made very clear because of the opioid problem throughout this country. Oh no, we can laugh all day long about open borders and laugh all day long about the impact on Texans right now, today, with fentanyl pouring into Texas, while my colleagues on the other side of the aisle don't give a whit, not one whit, about what's happening to Texans today, right now in South Texas. Right now, ranches getting overrun. Right now, human trafficking. Right now, sex trafficking. Right now, a little girl being moved up I-35 because we don't secure the border. And right now, some child in Texas dying because of an overdose of fentanyl. Now, I understand the argument here about the connection to the underlying bill. I get that. But I would note that when we're talking about the extent to which prosecutors have to go about their job in the U.S. Attorney's Office and make decisions about prosecuting, I think it would be great if this body, in the context of talking about how we're prosecuting cocaine offenses, could at least acknowledge the extent to which it is often laced with fentanyl. And we want to be very clear that when people are distributing fentanyl, that we are going to go after them, and that we are going to go after them with the full force of the law, because it is so extraordinarily damaging and dangerous. And again, I'll have more to say in a minute on the actual underlying bill, but I'm not going to be a part of hopping on this pendulum, swinging back away from criminal justice while Joe Biden runs away from his very efforts to make sure that we are responding to the crimes in the 1980s and responding to the scourge of the dangers that was occurring in inner city America and throughout the United States. And now the president, for political purposes, runs away from the very legislation that he put forward in order to try to attack the dangers that was occurring to people throughout our country, while we saw the increases as a resulted from the expansion of crack cocaine in 1986. We all know the history of that, and we've seen the history of that. And now today, we're seeing a history and a moment where fentanyl is pouring into our border through the southwest region of the United States for very obvious reasons, because we will not actually secure the border. And then we are now going to say, oh, we're not going to even talk about it here as we talk about winding back and pulling back from our obligation to ensure that we're enforcing the law against those who peddle these dangerous substances. Without
Gentleman yield.
I would yield
Mr.
to
Roy?
the gentleman from Louisiana.
With his 40 seconds that are left, I'll be brief. I'd echo and identify myself with everything he just said. This is a crisis. And here's the point, to answer Mr. Cohen. If it is, in fact, not related, as you say, I think the benefit of this amendment far outweighs the risk of saying something that may be superfluous. All it says is nothing in this section shall apply to the offense involving fentanyl, which is what you just said is already obvious. Well, why not put it in the language of the bill? There's no risk in doing that, and if there is indeed a nexus between cocaine products and them being laced or mixed with fentanyl, it directly relates. It's certainly germane, and it ought to be a part of the legislation. So I lend my voice of support to it. I yield back.
I yield back.
Gentleman yields back. The question occurs on the amendment to the amendment nature by Mr. Fitzgerald. All in favor say aye.
Aye.
Opposed, no. No. The noes have it.
Mr. Chair, yeas and nays.
The yeas and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
No.
Ms. Jackson-Lee votes no. Mr. Cohen?
Yes.
Mr. Cohen votes yes. Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No. No, I'm right here.
Oh, sorry, Ms. Bass.
That's right.
Ms. Bass votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Demmings? Ms. Demmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
As a Texan does give a twit, I vote no.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
No.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa? Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Spartz? Ms. Spartz votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Owens?
Aye.
Mr. Owens votes aye.
Mr. Chairman, how am I recorded?
Mr. Cohen, you are recorded as aye.
That was a mistake. I should be no.
Mr. Cohen votes no.
Mr. Isa?
Mr. Chairman, how am I recorded?
Mr. Isa votes aye. Mr. Gates, you are not recorded.
I'd like to vote aye.
Mr. Gates votes aye.
McBath votes no.
Ms. McBath votes no.
Are there any other members who wish to be recorded who haven't been recorded? Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 17 ayes and 23 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? For what purpose is Ms. Jackson-Lee seek recognition?
Mr. Chairman, you'll be glad that I do not have another amendment, but I do want to acknowledge two guests that are in the room with us temporarily, and in the spirit of bipartisanship and the hard work of Congresswoman Bass, I want to acknowledge Alicia Finley, president of the Botham Jean Foundation. Her brother met an untimely death by law enforcement, and Dr. Tiffany Crutcher, executive director of the Terrence Crutcher Foundation, her brother as well. They are here to add support to the judiciary work that we're doing, both in terms of the George Floyd Justice and Policing Act, which I hope will be bipartisan, continuing, and H.R. 40 because Dr. Crutcher is a resident of Greenwood, Oklahoma, Tulsa, Oklahoma, and of course, we know the Greenwood massacre and the idea of reparations, and she is here supporting H.R. 40 and the work that this committee is doing. And we thank you, Mr. Chairman, for the work that you're doing, and Congressman Bass, and we just wanted to welcome them here from Oklahoma and from Florida, New York. Thank you very much.
The chair extends the welcome on behalf of the committee. The question, for what purposes, Mr. Royce, seek recognition?
Move to strike the last word.
The gentleman is recognized.
Mr. Chairman, I appreciate the opportunity. When I first came to the Hill as a staffer in 2003, I worked on the Senate Judiciary Committee and came to know then Senator Jeff Sessions fairly well, along with his staff. And obviously, Senator Sessions went on to become the Attorney General of the United States. Senator Sessions is fairly well known for his efforts and belief as a former United States attorney and prosecutor to take the 100-to-1 ratio and reduce it and introduce legislation along those lines to do it. And I had many conversations with Senator Sessions at the time, asking him why, learning as a young lawyer, and talking to his staff about it, and came to the belief that the 100-to-1 disparity probably was, in fact, out of whack, and that we should make changes to that end. And there were a number of Republicans who worked with Democrats across the aisle to do that. Obviously, we saw a change in I think it was, my history is a little vague here because I wasn't on the Hill at the time, but 2010, 11, 12, when we came into the Obama administration, and then we saw that reduction from 100-to-1 to 18-to-1. I do believe that that is a step in the right direction and a good thing to try to get to the right place. But let's remember why. Let's remember why we embraced these changes in the 80s and the 90s. The levels of crime that we were seeing in our cities were at extraordinary levels. And it was, in fact, the Black community that came to Congress in large numbers, clergy, activists, organizations, asking for Congress to take action because of the highly addictive nature of crack cocaine, the highly negative impact on communities of crack cocaine. And so this was what the genesis of that was. And there was massive bipartisan efforts at the time, massive bipartisan agreement at the time. These are irrefutable facts. That's exactly what occurred. The question then becomes today, what do we do? And as we look today at significant rising crime, significant increases of crime in our communities, when we look today at the website of the Justice Department about gangs, gang violence has risen sharply, especially in large cities. There's a whole section in this section on the Department of Justice website of the nexus and the connection from gang activity to crack cocaine still today. The extent to which this is a massive problem in the communities. I then went back and looked at what Attorney General Sessions was talking about with respect to crime when he took over as Attorney General. This man who had spent a great deal of his life as senator trying to deal with the disparity issue, which we all recognize needed to be dealt with. And when he got to it, he talks about this, drug trafficking is an inherently violent business. If you want to collect a drug debt, you can't and don't file a lawsuit in court. You collect it by the barrel of a gun. And for the approximately then 52,000 Americans who died of a drug overdose in 2015, drug trafficking was a deadly business. We are now well past 52,000 drug overdoses in our country as we see the opioid epidemic raging. He wrote then, "My fear is that this surge in violent crime is not a blip, but the start of a dangerous new trend, one that puts at risk the hard-won gains that have made our country a safer place." I would just say to this committee how short our memories are as we now watch what is occurring throughout our country and the significant increase in crime, the significant problems that we see. I do not want to be a part of hamstringing our law enforcement community and the U.S. Attorney's Office and the prosecutors for being able to go after the baddest actors. Never in my time in the Office of the U.S. Attorney did I ever go try to lock up under federal law somebody who was, smoking a joint behind the bleachers at a football game, right? We were going after the worst actors, the ones that the state came to us and said, hey, this guy or this gal is a really bad actor and here's why. And you sit down and you work with law enforcement to do that. And then you look at what you've got and you look at the penalties in front of you, and then you go make a decision to go prosecute the worst offenders. I can talk chapter and verse about federalism. I've supported some of the laws about, let's defer to the states on their moves to make decisions about marijuana, for example. Crack cocaine and powder cocaine, these are lethal, dangerous drugs. And if we want to talk about disparity, I'm happy to talk about bringing down the powder numbers if we want to talk about something to further discuss disparity. But in my view, changing this by just a one-way ratchet of taking the 28 grams and going up, I think that's a problem. I think it'll hamstring our United States attorneys from being able to go after the worst actors in our country. And for that reason, I will ask for a roll call vote, and I will vote no. I yield back to the chairman.
Gentleman yields back. For what purposes Ms. Bush seek recognition? For what purposes? For what purposes Ms. Bush seek recognition? You're muted.
Can you hear me? I moved
Now
to
we
strike the
can.
last word.
Now we can.
All right. St. Louis and I thank you, Chairman Nadler. It has been a long-standing commitment for me and our St. Louis community to remedy the anti-Blackness and dehumanization that have informed crack cocaine disparities and allowed our criminal legal system to sentence thousands of people to mandatory minimum prison sentences. Growing up in St. Louis, I saw the crack cocaine epidemic rob my community of so many lives. I lived through a malicious drug war that saw Black people arrested and incarcerated for possession at a much higher rate than our white counterparts. As a nurse, I've watched Black patients be criminalized for crack use while white patients are treated for cocaine use. The vicious drug war that has prioritized punishment over treatment, violence over healing, and trauma over dignity has influenced and affected all of our lives. Our jails were not originally proposed to be treatment centers, and yet our jails have become some of the largest substance use treatment centers in America. People with a history of substance use are being sent to jails that are in no way equipped to treat their trauma or addiction. This is a public health crisis. Too often, drug offenses are born out of poverty. The system allows those with wealth to more easily escape the trauma of police raids, civil asset forfeiture, and mandatory minimums because they can afford top-notch treatment or they have been given a second chance while the rest of the country is left to hurt in silence. Today's consideration of the Equal Act is long overdue. Congress should never have imposed this inequity in the first place. For 35 years, rather than treat drug use, we've criminalized and stigmatized it. Too many times lives have been destroyed. Far too many families have been destabilized. And we talk about building families. And thousands of children have grown up without their parents because our prison systems have taken the place of treatment and wraparound care. That's the devastation caused by the crack cocaine sentencing disparity and ongoing trauma I've seen firsthand. I am compelled to support this legislation because the Equal Act will eliminate the disparity between crack and powder cocaine altogether and make the change retroactive, providing an opportunity for redress to those serving excessively long sentences due to this disparity. Rarely do we have legislation that not only addresses these issues, but is committed to redressing the decades of abuse and the violence this inequity has caused. I applaud my colleagues on this committee for advancing this important legislation that will undoubtedly help save thousands of lives. We must ensure this bill is not just passed, but signed into law, and that we also right the wrongs that this racist sentencing disparity has caused. This bill puts us one step closer to reducing the harms caused by a deeply carceral and punitive approach to public safety. It's long past time for it to end. I move to submit into the record a letter written by the Leadership Conference and the ACLU that discusses the importance of this legislation and how powerful it is that we have a legislation that addresses this issue retroactively.
Without objection.
Thank you, and I yield back.
Gentlelady yields back. For what purposes the gentleman from Colorado seek recognition?
Strike the last word.
Gentleman's recognized.
I am opposed to this legislation and would just tell the gentleman from New York that if he proposed legislation that increased the penalties for powder cocaine 18 times to to eliminate the disparity between these two drugs, I would welcome that. And I wonder sometimes where my colleagues, what world they're living in. At what point in time do we start speaking for the victims of crime on this committee and stop talking about mass incarceration and stop talking about racist implications of these, the laws that are passed. What I saw over and over again were dead bodies from drug overdoses, from murders. My friends that talk about these, jails and prisons being used as drug rehab centers, jails and prisons are used to incarcerate people who commit murder, who commit armed robbery, who commit burglaries, and commit a whole slew of violent crimes. And the people that are in there are often drug addicts, and they are driven to commit these violent crimes because of their addiction. Yes, we should be treating those addictions in prison, but we should be incarcerating people that commit these serious crimes. To pretend that we can somehow wave a wand and do away with violent crime is just crazy. We have to recognize that there is a direct link between the addictive nature of a drug and the other crimes that are being committed. Crack cocaine is different than powder cocaine. It is more addictive than powder cocaine. To treat it the same as powder cocaine is a mistake. It was reduced from 100 to 1 to 18 to 1 because much of the violence in our inner cities was reduced as a result of putting people away. And to suggest that criminals don't understand what the law is a mistake. I prosecuted across the river crack cocaine cases where mules were bringing these drugs up from Florida, and they had exactly 1 gram less than the mandatory minimum amount so that they wouldn't be caught in that particular law. Criminals know the law very well, and it acts as a deterrent. When we do away with laws like this, we do away with the deterrent effect of these laws. We see an increasing amount of violent crime in this country because we are not taking these drugs seriously enough. People talk about the war on drugs has failed. And I don't know that it's failed because we have too few drug rehab programs, which I'm absolutely in favor of. We reduced the crime rate in my judicial district while I was an elected district attorney with drug rehab programs. They're absolutely essential. But to suggest that we don't take the violent crime seriously and we don't recognize the impact on victims of crime from these dangerous drugs, I think is a serious mistake. And I would love to work with my colleagues across the aisle to make sure that we distinguish between those who have committed violent crimes and those who are merely addicted to drugs. But there is a very close correlation between those two.
Would the gentleman yield?
I'll be glad to yield.
Wouldn't the state laws still be in effect? And so if this guy is so smart that he knows not to bring the 1 gram in, that the state prosecutor in Colorado can still prosecute him?
Sure, and reclaiming my time.
Sure.
The purpose of arresting a mule is to work your way up an organization and be able to get the kingpins, whether they're in Jamaica, whether they're in Mexico, no matter where they are. So there is a purpose for the federal government to be able to go after someone carrying drugs and to make sure that you have a harsh enough penalty that encourages that person to provide information in return for a reduced sentence. So there is a purpose in the federal government engaging in that. But certainly the state government, the state of Illinois has the primary jurisdiction over a murder that is gang and drug related in Chicago, or the same in Los Angeles, the same in New York. The federal government has an obligation, in my opinion. Cocaine isn't grown in the United States. It's typically grown in Colombia and other countries and brought into the United States. And the U.S. government has an obligation under our laws to try to stop that importation. I yield back.
Gentleman yields back. The question occurs on the amendment. For what purpose does...
Move to strike the last word.
The gentleman, I will strike the last word and yield to the gentleman.
Thank you, Mr. Chairman. I just have great respect for the distinguished gentleman from Colorado, but I just wanted to make two observations or three observations. One, from the crime-fighting public service, public safety perspective, this change, the Equal Act, does have the support, as Congresswoman Demings indicated, of the major cities chiefs association. I think they're concerned about public safety and crime fighting, and has the support of the Association of Prosecuting Attorneys. I think they're concerned about public safety and crime fighting. It also has the support of the National District Attorneys Association. I think it's fair to say that they have great concern with public safety and crime fighting, not just retroactively, but the current situation as well as moving forward. And when you go back to the original 1986 law, I think it's widely understood that the notion that 5 grams of crack cocaine would yield effectively the same sentence of 500 grams of powder cocaine, as if there was no quantifiable difference between the two, is just extraordinary. 5 grams of crack cocaine essentially would be the equivalent of these two peanuts, which would yield the same sentence as, this is 450 grams, a little bit more than this bottle of powder cocaine, if it were powder cocaine. And so I think one of the reasons why you see people who are Democrats and Republicans, progressives, and conservatives, law enforcement organizations and civil rights organizations coming together is because they recognize that the original legislation was deeply flawed, had no justification under law, and even the revision has no current justification, in part because there's scientific evidence, medical evidence, that there is no pharmacological difference between how the body reacts to crack cocaine and powder cocaine. That was originally believed to be the case in 1986. But crack cocaine is not more highly addictive. That's just a medical reality. Though in 1986, that was the view. I'd also point out in 1986 that there are a lot of folks who believe that the original law, in part, was not simply a reaction to the violent crime that was taking place in many parts of America. Yes, that was the motivation of many, and Charlie Rangel acting in good faith, as has been indicated by members on both sides of the aisle. But there was another intervening event, and that was the death of Len Bias, who was a star basketball player. Many people thought he could rival Michael Jordan. He had just been drafted by the Boston Celtics, and the night after he was drafted, he dies of a drug overdose. And it was a national story. And Congress reacted. That was a horrific death. But Congress reacted a few weeks after Len Bias's untimely passing by comparing this amount of powdered cocaine to this amount of crack. And it was wrong. And Democrats got it wrong. And there were some Republicans who got it wrong. It's a Democratic House, and it was a Republican president. And Democrats and Republicans today are coming together to try to fix that wrong, which was in part inspired not by the evidence of what was happening all across America, but by Len Bias's death. As tragic as that was, we can't make public policy on that basis. And we've seen the consequences decades later of what happens when we do just that. So I'm just thankful for all of my colleagues who have different views, some supportive of the Equal Act, some who perhaps believe that we should maintain what currently exists. And this has been a very positive discussion of people with different views. But I just wanted to make sure that the record reflected that the science is very clear now, and that the motivations, in part, in 1986, weren't simply what was happening across the country, but it was a reaction to a particularly sensationalized event that led to doing something that clearly had adverse consequences for significant communities, not just Black communities, for low-income communities of every race, not just in the inner city, but in rural America and small-town America and in Appalachia as well. And I yield back.
Reclaiming my time, I just want to point out also that there are mandatory minimums for cocaine. The bill before us equalizes the penalty for the two different forms of cocaine, which are medically indistinguishable in its effect, but there are mandatory minimums. Now, maybe we ought to reduce those mandatory minimums, maybe we ought to increase those mandatory minimums, but they're there. And this bill simply recognizes a medical reality that the two forms of cocaine have the same pharmacological effect. I yield back. Does anyone else seek for our purpose, does the gentleman seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I just want to quickly read in response. I appreciate the gentleman from New York and the law enforcement organizations he cited. I want to read from the National Association of Police Organizations, Inc. Quote, as crack is usually sold in much smaller quantities than powder cocaine, NAPO believes that tinkering with the current sentencing structure will negatively affect the work law enforcement has done to protect our nation's communities from the crime and violence associated with crack cocaine. The reduction of crack cocaine penalties will only accelerate the destruction brought to our neighborhoods by those convicted of federal crack offenses, close quote. With that, I'll yield to my friend from Colorado.
I thank the gentleman for yielding, and I want to indicate to the gentleman from New York, the sponsor of this bill, that I have great respect for him and don't question motives at all. And I, in my experience, crack cocaine is more addictive. And I want to just read something. I just looked this up on my phone. Thank God for phones where we can get this information. But I just find it hard to believe that crack is not more addictive. And according to WebMD, an article on WebMD, crack is inhaled through the lung and spreads through the body, producing the high much more quickly and lasts for a shorter time than snorting cocaine, said John Giordano, an addiction counselor and the founder of National Institute for Holistic Addiction Studies. This causes a cycle of binging and crashing, which puts the user at a greater risk of dependence. And there are several other experts who are quoted as saying the same thing. So I respectfully disagree about the addictive qualities of crack cocaine and would suggest that there should be a disparity in the sentencing treatment of that. And I yield back to my friend from Arizona.
Chairman, I yield back.
Gentleman yields back. Are there any further amendments to the amendment in the nature of a substitute? In that case, the question occurs on the amendment in the nature of a substitute as amended. This bill will be followed by immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no.
Aye.
In the opinion of the chair, the ayes have it. The amendment in the nature
Mr. Chairman.
of a substitute is agreed to.
Mr. Chairman.
The reporting quorum being present, the question is on the motion to report the bill H.R. 1693 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably to the House. The ayes and nays are requested. The clerk will call the roll.
Thanks, Mr. Chairman.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen?
Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass?
Aye.
Ms. Bass votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Stemmings? Ms. Stemmings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes no. Ms. Spartz? Ms. Spartz votes yes. Mr. Fitzgerald? Mr. Bentz?
Mr. Benz votes yes.
Mr. Bentz votes yes. Mr. Owens?
Mike wasn't.
Mr. Owens?
Mike's not on, Burgess.
Mr. Owens, put on your mic. Yeah, why don't you try thumbs up or thumbs down since we can't hear you? I'll take that as an aye vote. Okay,
Mr. Owens votes aye.
Mr. Chairman, how am I
Mr.
recorded?
Raskin?
I vote aye.
Mr. Raskin votes aye.
Mr. Fitzgerald?
Mr. Fitzgerald votes aye.
The clerk will report.
Mr. Chairman, there are 36 ayes and 5 noes.
The ayes have it. The bill is amended, is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 4035, the Real Justice for Our Veterans Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4035, to amend the Omnibus Crime Control and Safe Streets Act of 1968 to prioritize veterans' court treatment programs that ensure equal access for racial and ethnic minorities and women, and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 4035, the Real Justice for Our Veterans Act of 2021, is an important bill to buttress the Veterans Court system by ensuring that the most effective rehabilitative treatments are implemented and are available to all veterans who need them. This bill would also expand access to rehabilitative services to veterans who would otherwise qualify for treatment and alternatives to incarceration, but who do not have a Veterans Treatment Court in their jurisdiction. For more than a decade, Veterans Treatment Court programs around the country have successfully provided support to veterans struggling with substance abuse or mental health issues. These courts allow qualifying veterans to receive court-supervised comprehensive treatment provided by the Department of Veterans Affairs or community organizations providing mental health or substance abuse treatment. Because veterans courts across the country offer so many different and wide-ranging services, comprehensive data collection is needed to discern and replicate the most promising methods. That is why the Real Justice for Our Veterans Act would expand data collection on the effectiveness of certain treatment practices in reducing recidivism. In addition, the bill would ensure that referrals to veterans treatment courts are determined in a fair and equitable manner. The bill would also establish a pilot program to examine promising and innovative treatment and rehabilitation programs. Finally, the bill opens up treatment courts to veterans who otherwise qualify for Veterans Treatment Court, but who live in a jurisdiction where a Veterans Court has not yet been established. In doing so, the bill ensures that the maximum number of veterans are offered the chance to get the support they need and to avoid incarceration. These are modest but important changes to the Veterans Treatment Court program, and these improvements come at a time when our country stands at an inflection point. Nearly 20 years of war in Afghanistan are coming to an end. Over the course of the last 2 decades, millions of American service members have served abroad fighting on behalf of our nation. As the final troops come home, we must answer the call, as a country, to support veterans and their families during any and all challenges that they face. As of this year, there are roughly 21 million veterans of the United States Armed Forces. Among these veterans, there are over 1 million people diagnosed with service-connected disabilities, in addition to the many more who may not have had an official diagnosis. By some estimates, nearly 1 in 10 veterans who return home from the wars in Iraq and Afghanistan will have an encounter with the criminal justice system. Of those incarcerated veterans surveyed by the Bureau of Justice Statistics, 48% of those in prison and 55% of those in jail reported that they had been told by a mental health professional that they had a mental health disorder. The Bureau of Justice Statistics found that the number of incarcerated veterans who had seen combat who reported mental health disorders was even higher, 60% of those in prison and 67% of those in jail. Another study, conducted in the first decade of the Iraq and Afghanistan wars, estimated that 1/3 of service members previously deployed to Iraq or Afghanistan suffered from post-traumatic stress disorder, PTSD, major depression, or a traumatic brain injury, TBI. Despite these somber statistics, there is some hope. Veteran defendants who successfully complete Veterans Courts programs can avoid jail time, receive needed treatment, and have their records expunged. That is why today we take up the Real Justice for Our Veterans Act of 2021. The beneficiaries of expanded and improved Veterans Treatment Court services are some of the most deserving of our fellow Americans. They have sacrificed on behalf of their country, sometimes returning home with unseen wounds of war. These programs provide veterans with holistic rehabilitative services that reduce recidivism rates and ultimately benefit individuals as well as the community at large. I am proud to be a co-sponsor of this important legislation, and I thank Chairwoman Jackson Lee for her leadership as the author of this bill and for her continued dedication and support to our veterans. I support this bill, and I urge its quick adoption by the committee today. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. The United States of America is the greatest country in the history of the world. Frankly, I think we should say a little more often around this place. And a large part of that reason, of course, is for the greatness in the men and women of our military. These men and women and their families make sacrifices for our country. Sometimes they make the ultimate sacrifice. And the wounds of war oftentimes follow our heroes home. Many veterans suffer from substance use disorders, mental health conditions, and trauma. As a result, many veterans end up in the criminal justice system. Veterans treatment court programs are modeled after other treatment court programs, such as drug treatment courts, to provide services specific to meet the unique needs of a group, in this case, our veterans. Veterans treatment courts are not only designed to benefit veterans in the criminal justice system, but taxpayers as well. These programs lower recidivism for participants who complete them, saving money that would have otherwise been spent on incarceration. The bill before us today authorizes a pilot program to make grants to improve retention rates in veterans treatment court programs. It also allows veterans in jurisdictions that do not operate veterans court programs to participate in drug courts instead. I appreciate the bipartisan work on this legislation and look forward to our discussion and this bill moving. Thank you.
Gentleman yields back. I now recognize the Chair of the Subcommittee on Crime, Terrorism, and Homeland Security, the gentlelady from Texas, Ms. Jackson Lee, for her opening statement.
Greatness of our nation, recognized our greatness through the whole idea of the men and women who serve. And over the years, we have faltered in our response to their needs. There is no doubt, if we begin in our present lifetime to look at some of the wars that we currently have history of, starting with the Vietnam War, not ignoring World War II or the Korean War, World War I, or any others, but we have a current image of Vietnam vets, of whom we note that many of them are homeless and many of them are afflicted with the disease of drug usage and, of course, abandonment, PTSD, and that transcends itself or continues through our soldiers in other conflicts, including both Iraq and Afghanistan. They cry out for help. So I thank you, Mr. Chairman, for calling up my bill, H.R. 4035, the Real Justice for Our Veterans Act. I recall introducing some years ago when Chairman Murtha was alive. He worked with me extensively to create an off-site PTSD center away from a veterans hospital in a neighborhood where veterans could come who were homeless to get treatment for PTSD. It was like a bright light, and I hope this bill will be a bright light. This straightforward bill would build upon the ongoing success of veterans courts. It will also ensure that the most effective alternative treatment courts are accessible to all qualified veterans. As amended in the nature of a substitute, this bill has three primary goals. First, the bill would expand data collection regarding the effectiveness of veterans courts. Second, it authorizes a pilot program that would investigate and promote promising retention models in veterans and drug courts. Third, it would open up drug treatment courts to veterans in areas where there may not be a veterans court. There is a great disparity between the number of drug courts and the number of veterans courts. We want our veterans everywhere to have access to the idea of treatment for whatever ails them as relates to their war duties or their military service. In doing so, this provision enables veterans who qualify for veterans courts to participate in a drug treatment program in locations that haven't established a veterans court yet. This measure would ensure that access would be available to a broader number of qualifying veterans, even those that may have more serious past offenses. The Veterans Court program from my hometown of Houston, Texas, inspired this legislation. In 2009, Harris County created the first Veterans Treatment Court in the state of Texas. In Harris County, our Veterans Treatment Court provides program participants with integrated treatment services, including traditional substance abuse treatment, vocational rehabilitation, mental health care, and veterans benefits. These programs, along with additional support from the Veterans Administration, provide judges, prosecutors, and participants a wide range of rehabilitative options. Even though current data is limited, there is sufficient evidence to suggest that other veteran treatment courts across the country could benefit from adopting the innovative practices underway in Houston and elsewhere. The need for more widespread, innovative, and multifaceted approaches is clear. By one estimate, approximately 9% of veterans who served in Iraq and Afghanistan have been arrested since returning home. Again, 9% of veterans who served our country, some wounded in Iraq and Afghanistan, seen their brothers and sisters having lost their life in battle, have been arrested since returning home. Based on the most recent data, the Bureau of Justice Statistics estimates that approximately 181,500 veterans were incarcerated in jails as well as state and federal prisons. Veterans have served our country and deserve the best chance at a successful rehabilitation possible. I would indicate that in some of our visits to the prison system, we have met some of these veterans. In addition, this legislation authorizes a new pilot program that will allow DOJ to test promising retention programs that promote greater enrollment and participation by veterans through the duration of their treatment program. If there's a rehabilitative therapy out there that can improve veteran outcomes and reduce recidivism, return them to their families, their lives, and their occupations, we should be dedicating the resources to test out the model. Expanding access for veteran rehabilitation means offering those who live outside a jurisdiction that has Veterans Court the chance of rehabilitation and access to a Veterans Court, which is the underlying purpose and value of this legislation. Currently, the federal law bars those who have a past violent conviction from participating in drug treatment courts. The same is not true of Veterans Courts. Veterans who have a past conviction and are otherwise qualified may be referred to a Veterans Treatment Court. We do owe these service members, these persons who have been in battle, who have experienced things that we have never seen, we owe them their moment of justice. The effect of this ban means that veterans who have a past conviction and live in one of the approximately 1,500 jurisdictions where there is no Veterans Court, but there is a drug treatment court, are barred from participating in rehabilitative treatment. This is absurd, and my bill corrects this error. In the immediate future, I also plan to introduce legislation eliminating the so-called previous conviction bar from drug treatment courts, regardless of past offenses. Any qualified participants should be considered for these meaningful programs. A life changed around is a life that is better for this nation. Past legislative efforts to strengthen veterans treatment courts have yielded broad support. I hope my colleagues on the committee in bipartisan manner will support this bill today. Mr. Chairman, thank you for your courtesies. I yield back.
Gentlelady yields back. I now recognize the ranking member of the Crime Subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statement.
Thank you, Mr. Chairman. We owe much of what we value in this country to our veterans. Our veterans have earned our respect and our gratitude. Sometimes we don't do enough to recognize the sacrifices they have made for this great country. Unfortunately for some, the trauma they experience on the battlefield doesn't stay there. It follows them home and manifests itself in substance abuse and/or mental health problems. Those problems can lead veterans to finding themselves in the criminal justice system. Veterans courts provide an opportunity for these veterans to receive treatment and assistance that may help address underlying conditions and prevent them from facing more serious repercussions. In a number of jurisdictions in my home state, we have these types of courts for veterans and also substance abuse courts. They have been highly effective. This bill aims to strengthen veterans court programs, which will hopefully help our veterans not find their way back into the criminal justice system. Chairman Nadler mentioned traumatic brain injury and PTSD. Indeed, there are many veterans who suffer from the effects of traumatic brain injury, or TBI, and PTSD. A proven aid to veterans with TBI and PTSD is hyperbaric oxygen treatment. HBOT should be recognized by the Veterans Administration, and HBOT should be regularized as treatment for veterans suffering from PTSD and TBI. I hope that that will become part of the treatments that are offered through the veterans courts as jurisdictions expand and use these more regularly. With that, Mr. Chairman, I thank you for the opportunity, and I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 4035, offered by Mr. Nadler. Strike all after the enactment
Without
clause.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute makes one substantive change. As introduced, the Real Justice for Our Veterans Act of 2021 contained a preference for veterans courts grant applicants that meet certain conditions. The amendment eliminates that preference consideration. Instead, the Attorney General's report will include an analysis of referral practices, including consideration of demographic information. This is a modest but important change, and I urge all members to support the amendment. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Ms. McBath seek recognition?
Thank you, Mr. Chairman, and I really want to thank our colleague, Representative Sheila Jackson-Lee, for bringing forth this really important piece of legislation, as I myself work a great deal with the veterans community in my district. And I know that one of the privileges that I've had in Congress is to work to improve the lives of those that have really given so much to our country and to our nation, and that is our veterans. And I come from a family of many veterans, and I'm proud to have a veteran actually working in my district office to help serve our veterans in our community. We all know that our veterans sometimes pay a great cost in terms of their physical health in service to our country, but many also suffer from depression, anxiety, PTSD, and other mental health conditions. And some also face the burdens of addiction. Veteran treatment courts play an important role in helping our veterans who have mental health or drug problems when they get involved with our criminal justice system. And often these people who need just simply treatment, counseling, and mentorship, not a prison sentence. While every program is different, they are all designed to provide structure, accountability, and a path forward for those who are willing to get the treatment that they need or to do the hard work of facing their own addictions. And I've been proud to support our veteran treatment courts in my community, and this bill will make sure that more veterans get the help that they need to get back on track again and to again become the pillars of our communities that they really so often are. And I am pleased that this bill has provisions that will improve data collection. With this data, we can better develop the best practices for veteran treatment courts and do even more to reduce recidivism. We'll also be able to see whether or not these courts are serving the needs of all our veterans, including women and most specifically veterans of color. Our brave men and women, they sacrifice so very much to protect our democratic ideals. And when they end their service, we must see to it that we take care of them, whether their needs are physical, mental, or behavioral. And the Real Justice for Our Veterans Act is a part of that effort. And I thank Congresswoman once again, Sheila Jackson-Lee, and the chair of the Crime Subcommittee for introducing this legislation. I'm pleased to support it, and I yield back the balance of my time.
Gentlelady yields back. For what purposes does Ms. Ross seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you very much, Mr. Chairman. This bill, led by our colleague, Congresswoman Jackson-Lee, marks a critical step in ensuring that our veterans are properly cared for within our criminal justice system. Veterans suffer disproportionate rates of substance abuse and are often related to mental illness. Such mental health disorders, if untreated, can lead many veterans to become involved in the criminal justice system. My dad was a psychiatrist in the Air Force during the Vietnam era and saw the effects that war can have on our service members. Treatment courts provide a key resource for veterans because their judges have demonstrated experience in handling veterans' cases and understand factors that lead to veteran involvement in the criminal justice system. These courts possess institutional knowledge of veteran-targeted resources that can be offered in lieu of incarceration. As a representative of a state and a district with a large veteran population, I care deeply about ensuring that gender or race does not dictate access to veteran treatment courts. I urge my colleagues to support this legislation as a promising path forward to care for our veterans who have sacrificed so much for our country. And Mr. Chairman, I yield back.
The gentlelady yields back for what purposes Ms. Scanlon seek recognition.
Thank you, Mr. Chairman. And I also want to thank Chairman Jackson-Lee for her leadership in introducing this important bill. As several of our colleagues have mentioned, too often our veterans suffer wounds of war that make them more vulnerable to substance abuse, disorder, and mental health challenges that can lead them into the criminal justice system. I want to share a few words from a veteran who now serves in Philadelphia's Veterans Treatment Court. After returning to Philadelphia from Iraq in 2003, it took me only 4 days to see the inside of a jail cell. I was arrested for aggravated assault. My drinking and eventually drugging had given me all of what I thought I needed to transition back into society. I was wrong. It was exactly what I didn't need. I put a Band-Aid on my emotions by using substances to get through each day. Those substances destroyed my life. I had 7 arrests and spent a year in prison. I lost my family, and what hurt the most was not being with my daughter for the first 4 years of her young life. Something had to change if I was going to survive. After my final arrest, I was put into the Philadelphia Veterans Court. There is no question it saved my life. I found other veterans who were all working on the same mission, the mission of recovery. Help is what we get in veterans treatment courts. My life began to change. After graduation from Veterans Court, I decided to stick around and continue to be a volunteer for the new veterans coming into court each week. My mission about recovery isn't just about me, it's the younger version of me who was about to see the inside of a jail cell for the first time. What veterans courts do is make sure that veterans don't see the inside of those jail cells more than once. For veterans who rely on the veteran treatment courts for substance abuse and mental health treatment services, it's critical that we ensure that those programs are using evidence-based treatments. This bill will accomplish that while also guaranteeing that the quality and access to care is equal for racial and ethnic minorities and women. I'm also glad to see the language includes a pilot program that aims to improve retention rates in veteran court treatment programs and encourage programs to improve their completion rates. Veterans who've sacrificed their physical and mental safety for our country should have the highest level of care upon their return. This includes access to substance abuse and mental health resources, as this bill ensures, and also legal aid to ensure that they can take advantage of the programs they're entitled to. That's why I've introduced the bipartisan Veterans Medical Legal Partnership Act, which would provide grants to state and local governments to create medical legal partnerships aimed at ensuring access to legal services for veterans, ultimately reducing homelessness and recidivism and preventing victimization among former service members. I look forward to working with my colleagues to move that bipartisan piece of legislation and other veteran-focused legislation through our committee. And I encourage my colleagues to support the Real Justice for Our Veterans Act, which would make meaningful change for our veterans. Thank you again, Chairwoman Jackson-Lee, for your leadership and in focus on this important issue. I yield back.
Gentlelady yields back for what purpose does Mr. Correa seek recognition?
Move to strike the last word, Mr.
Gentleman is
Chairman.
recognized.
And I also want to stand to thank my colleague, Ms. Jackson-Lee, for this important legislation. In my home county, Orange County, California, we also have a drug court, treatment court, homeless court, veterans court, and I've seen the difference that these courts can make in a person's life. Instead of having a confrontational criminal court environment, a prosecutor, defense attorney, probation officer, social service workers, all teaming up to make sure that veterans receive the services they need to get back on their feet. This bill is a tremendous step forward, but it's not enough. We also have veterans that have fought for our nation, served with honor, and have it discharged honorably. And these vets, legal immigrants with green cards, get into trouble because of things like PTSD and then have their green card and residency removed, pulled, and are then deported. These veterans, under current law, cannot return to the United States. However, once they die in foreign soil, they can have their bodies returned to the United States and buried in a national cemetery. What a terrible travesty of justice. As has been said many times here today, our veterans deserve better. And with that, I yield.
Gentleman yields back. Are there any amendments to the amendment in the nature of a substitute? The question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed,
Aye.
no. In the opinion of the chair, the ayes have it. The amendment in nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 4035 is amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. For what purposes does Ms. Jackson-Lee seek recognition?
Mr. Chairman, I'm pleased to ask to be able to submit into the record a letter of support for the Real Justice for Our Veterans Act from the National Association of Drug Courts Professionals. I ask unanimous consent to submit into the record.
Without objection.
And I'd like to submit into the record article from the New York Times, suicides among post-9/11 veterans are 4 times as high as combat deaths, and a new study finds, June 22nd, 2021. Ask unanimous consent.
Without objection.
Thank you. Thank you, members.
Pursuant to notice, I now call up H.R. 3372, the One Stop Shop Community Reentry Program Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3372 to authorize implementation
Without objection, the
grants.
bill is considered as read and open for adoption for amendment at any point. I will begin by recognizing myself for an opening statement. I am proud to support H.R. 3372, the One Stop Shop Community Reentry Program Act of 2021. This bipartisan, bicameral legislation, which passed the committee in the House last Congress, would authorize grants to community organizations to create centralized reentry intake and coordination centers. These centers would serve as the home base for individuals recently released from correctional facilities as they go through the difficult process of rejoining their communities. At one-stop reentry centers, reentering individuals would be provided personalized, step-by-step assistance to access the resources, both public and private, that are needed to successfully integrate back into the communities. At the one-stop center, re-entering individuals would be given assistance at every step of the way, from the moment they are released until they have the capability to fully rejoin their communities. This important legislation recognizes that a comprehensive reentry approach is needed to improve reentry outcomes, which ultimately has the effect of improving public safety. The bill adopts a whole-person approach that would ensure that all elements of a returning individual's life are supported. This includes transportation to and from appointments, temporary housing, assistance supplying for benefits, and job training. Additionally, for those who have formal reentry plans, the one-stop community reentry centers proposed by this bill would also provide case management and wraparound support. The challenges faced by individuals returning from prison are great, and they warrant the type of support the One-Stop Community Reentry Program Act would authorize. Unfortunately, the reentry support services that many prisoners receive while incarcerated do not sufficiently prepare them for the transition back to their communities. Many incarcerated individuals also have pre-existing conditions that make reentry even more difficult. Physical disabilities, mental health concerns, and substance abuse issues further complicate reentry plans, and additional support, like those detailed in H.R. 3372, are needed to promote successful outcomes. Specialists employed at one-stop centers can build relationships with providers, private groups, religious organizations, and public agencies to build networks of support that will help returning individuals get the care and support they need to succeed. Inadequate reentry support leads to recidivism and unnecessary financial strain on the community. Both the short and long-term costs associated with incarceration pale in comparison against the minimal front-end costs associated with a successful reentry. Of the few studies that have assessed the effectiveness of reentry services, a number have found that more robust and comprehensive reentry services are better at reducing recidivism and promoting the long-term success of reentering individuals. This bill offers greater opportunities for success for individuals returning from prison as well as their communities. I thank Representative Bass, Representative Reschenthaler, and their bipartisan co-sponsors for introducing this important legislation again, and I urge my colleagues to join me in supporting the bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Successful reentry into society helps reduce recidivism, improve public safety, and save taxpayer dollars. We have seen successful criminal justice reform programs, including reentry programs, work in Republican-led states like Texas. This is a worthwhile goal and something that President Trump and his administration prioritize. H.R. 3372 would build on President Trump's strong record of criminal justice reforms, and I'm pleased that my Democrat colleagues are following his lead. In 2018, he signed the First Step Act into law. The First Step Act reauthorized the Second Chance Act, a 2007 law aimed at reducing recidivism and improving outcomes for people returning from incarceration. H.R. 3372 applies a holistic approach to reentry to achieve results that are more favorable to the offender and to our communities. While this goal is important, I do think it's important we understand the bill authorizes programs duplicative of existing federal grant programs already authorized by the Second Chance Act. In other words, grants that would be created by H.R. 3372 can be funded currently with currently authorized and appropriated programs. Overall, I think this is a good piece of legislation, and I yield back.
The gentleman yields back. I now recognize the chair of the Subcommittee on Crime, Terrorism, Homeland Security, the gentlelady from Texas, Ms. Jackson Lee, for her opening statement.
Thank you very much, Mr. Chairman, and thank the author of this legislation as well. I rise in strong support of H.R. 3372, the One-Stop Shop Community Reentry Program, and applaud our colleague, Representative Karen Bass, for authoring this bill and for her work on important reentry issues. This bill is a compassionate, common-sense measure. It makes sense for the individual leaving incarceration and the community that they are returning to. All but 5% of people who are incarcerated are eventually released. That means 95% of those currently incarcerated will have to make the difficult journey to reenter and make a new life for themselves. Starting life anew is difficult enough. We know it. We know these people. They are our neighbors in our community. The journey is even more difficult for a previously incarcerated individual. Many previously incarcerated individuals will return to their neighborhoods that they barely recognize without jobs or a place to live. Many will not have basic job skills to compete in the modern economy, and only the lucky few will have family members or friends there to assist them through this difficult transition. H.R. 3372 would provide the critical link between the reentering individual and the resources they need to succeed to come out of incarceration. The single point of information makes referrals and carrying out reentry plans substantially easier and therefore more likely to succeed. The concept that this bill promotes from release to self-sufficiency is critical to successful reentry efforts. Many of us have visited shelters or veterans facilities, and we see the veterans there, many of them young, who are also individuals who have come out of prison. They need help. To connect these individuals to the resources they need, the bill would authorize a 24/7 reentry hotline to connect these recently released with reentry services near their home. The reentry hotline would maintain a list of reentry services throughout the United States for individuals who are released into smaller or new communities. The public safety benefits of this legislation are clear. Reentry success produces cost savings and community benefit. This bill provides citizens leaving prison with the necessary tools and resources to be economically self-sufficient. It gives reentering individuals a stronger chance. That's why I am such an enthusiastic supporter of this bill. I again thank the chairman for taking up this legislation and applaud Representative Bass for authoring this important bill. With that, Mr. Chairman, I yield back.
And now, the gentlelady yields back. I now recognize the ranking member of the Crime Subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I support reentry programs. They do help in the reduction of recidivism, and that in turn helps improve our public safety. However, I am opposed to the federal government bribing the states to implement policies. We see this all too often in this committee. And as one who is a strong believer in federalism, this continues to undermine my goals of restoration of federalism and actually the separation of powers, as James Madison described it, both horizontally and vertically. So many of the bills we see before this committee are just bribes to the states to implement a particular policy. The grants created by this bill are also duplicative of existing grants authorized by the Second Chance Act. If state and local governments need additional funding, they should provide that funding, especially with the dollars that have been sent their way from the federal government over the past year. It is not the responsibility of the federal government to provide grants to states and local governments to cover their expenses. Instead of creating new grant programs, members should work with their state legislatures, city councils, or other local government bodies to address these issues. We need to get serious and recognize the financial crisis facing our nation as well. We need to find a way to address these issues without increasing spending. I will be opposing the bill. I yield back.
The gentleman yields back. I'm pleased to recognize the author of the legislation, Congresswoman Bass.
Thank you. I'm going to strike the last word. I want to thank the chairman for once again bringing this bill up for consideration the second time in the past 2 Congresses we considered it. The One-Stop Shop Community Reentry Program Act, which I've introduced along with my colleague, Representative Guy Reschenthaler and Representative Owens, will fill a critical void in reentry services by providing resources for state and local jurisdiction to make grants to establish a more centralized process for assisting individuals who are reentering their communities after a period of incarceration. Madam Chairman, during the debate over the Equal Act, we discussed how the sentencing laws for cocaine led to a disruption of families and neighborhoods. We all know the statistics. More people are incarcerated in the United States than anywhere in the world. During the war on drugs, during the Get Tough on Crime period, we actually abandoned rehabilitation and just focused on punishment. We passed hundreds of laws that banned people who were incarcerated from participating in the legal economy, from working, from living in certain areas. Arrests then were concentrated in certain zip codes, and individuals are then returned to these zip codes. When our laws effectively block people from working or fully participating, unfortunately, they will survive by any means necessary, so it's no surprise that without options, many return to crime. In California, the recidivism rate has been close to 70%. People cycle in and out, destabilizing families and disrupting neighborhoods. This bill will assist in reducing crime in areas that are disproportionately impacted by assisting individuals reintegrate to the legal economy, find housing, access to health care. Last year, when the Subcommittee on Crime, Terrorism, and Homeland Security held a hearing entitled Returning Citizens, Challenges and Opportunities for Reentry, at that hearing, we heard about the challenges that many individuals face. So imagine you're incarcerated for many years. During the time period of your incarceration, you were diagnosed with diabetes, placed on insulin, or you were diagnosed with schizophrenia, placed on antipsychotic medication, and then you are released back into the community with no access to health care. Your medicines are cut off. You don't have an ID. You can't get a driver's license because you owe back child support. You don't have a place to live. You can't associate with people who've been formerly incarcerated, even though there might be members of your family that were formerly incarcerated or certainly in your neighborhood. So these challenges can oftentimes be insurmountable. And we must figure out how to address them because access to support services is so critical to successful reentry. And if you don't care about the individuals, that's unfortunate. But understand that when people are arrested and incarcerated in concentrated zip codes and you return them to those neighborhoods and block them from any way to be reintegrated into the legal economy, you actually contribute to crime in those areas because you leave people without options. The one-stop shop model that this legislation supports would provide a full panoply of reentry services all at a single location, calibrated to address the critical elements of the reentry process. Critical services such as housing and job training, navigating access to health care would be available at the one-stop centers. And hopefully these centers will be led and staffed by people who were formerly incarcerated. In addition to one-stop centers, this bill authorizes the Attorney General to establish a 24-hour, 7-day-a-week reentry service assistance hotline to direct recently released individuals to appropriate reentry services in their locations. When Congress passed the hallmark Second Chance Act that the ranking member talked about, we demonstrated our commitment to provide housing, employment, assistance, substance abuse treatment, and other related services to returning individuals with the goal of reducing recidivism. This one-stop shop bill would go a step further by ensuring that returning citizens can actually access these services. One of the things that we have done with reentry resources, both on a federal level and on a state level, is we've given those resources over to probation. People still have difficulty accessing the services that are supposed to be available in the Second Chance Act. And so without critical reentry services, without programs that are led and staffed by people who were formerly incarcerated, who can do the hand-holding that is frankly inappropriate for law enforcement or probation to do, people will continue to fall through the cracks and won't be able to access the services that are provided in legislation that we pass, such as the Second Chance Act. So we must help to facilitate this access, which will also help to ensure a reduction in recidivism, help to keep our communities safe, and reduce crime. So I want to thank the chairman, I want to thank the co-sponsors for this bill, and I urge my colleagues to support this measure today. I yield back.
Gentlelady yields back. For what purpose does Ms. Scanlon seek recognition?
Thank you, Chairman. I move to strike the last word.
Lady is recognized.
Thank you. Hundreds of thousands of people are released from custody each year, and reentry services provide a crucial tool to help them find success back at home. But a lot of the time, returning individuals are given too little or no resources to support them as they reintegrate in our communities. Too often, they struggle to access safe and affordable housing, educational opportunities, and steady employment once they're home. This bill would provide critical, accessible, and comprehensive resources to individuals returning home, like job skills training and help obtaining IDs, housing, mental health services, and more. Importantly, this bill would expand two services that I view as critical to increasing the success of reentering citizens: legal assistance and opportunities for mentorship as part of reentry services. For years, I had the opportunity to work with a reentry program started by judges in the Eastern District of Pennsylvania with the goal of reducing recidivism, the STAR program. It became a model for federal courts, recruiting volunteer attorneys to represent returning citizens to address the myriad legal issues that impeded their success in reentry, whether it was getting a driver's license reinstated so that a person could get a job, or helping them secure housing or medical insurance. All of these things were providing blocks to people being able to successfully reenter. In addition, this program provides an opportunity for mentoring. And as chair of the Bipartisan Congressional Youth Mentoring Caucus, I know how valuable mentorship can be in helping individuals navigate the challenges of returning home after incarceration. Mentoring is an evidence-based initiative that leads to positive outcomes in areas like employment and educational attainment. And it's important that returning individuals have access to this support. So thank you, Mr. Chairman, for putting forth this critical legislation for our consideration today. And thank you to Representative Bass for introducing this important bipartisan bill. I look forward to voting to pass the One-Stop Shop Community Reentry Program Act out of committee today, and urge all of my colleagues to support this bill. I yield back.
Gentlelady yields back. For what purposes Mr. Tiffany seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment. Gentlelady reserves
Reserve a point of order.
Amendment to H.R. 3372, offered by Mr. Tiffany of Wisconsin. Page 15.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Okay, thank you. Thank you very much, Mr. Chairman. So I share this important amendment with you today, and in a nutshell, what it is a maintenance of effort provision to make sure that we're protecting funding for our law enforcement. I mean, we're hearing across the country the clarion call of defund the police, and some people in some cities are following through with that, and we're seeing the results of higher crime. So I'm asking for your support today for this amendment to the One Stop Community Reentry Center grant program. Today, we are seeing bills that aim to lessen the penalties for those who willingly choose to break our laws, victimize families, and harm our communities. Crime rates are soaring across America. It's important that we support those who enforce the laws of this nation, those men and women who sacrifice each day to make our communities safer, from those who are beneficiaries of reduced criminal penalties and no cash bail systems. My amendment does that and prohibits grant money from being awarded to states who arbitrarily and capriciously defund their police departments to appease the loud minority. If we are proposing giving grants to reintegrate convicted criminals into society, we must also never forget the hard work and sacrifices made by those who investigate the crimes, protect the victims of crimes, prevent crimes, and bring those same criminals to justice. I strongly urge my colleagues to support this amendment to show solidarity and support for our law enforcement and first responders. Mr. Chairman, this is really an important amendment to this to make sure that the funding is getting to where it is supposed to. And that's why I term it a maintenance of effort provision, so that the funding for law enforcement agencies is protected. And I hear the continued talk about the First Step Act. That was such an important piece of legislation. Other pieces of legislation here that are reducing criminal penalties, that they are so important that there's a better way to go about this than there was 30 to 40 years ago. Well, I have to say that if the funding does not stay with our police departments, which this amendment will make sure that it does, your actions could jeopardize things like the First Step Act. I mean, this is a great experiment that's going on in America right now. And I can tell you, Americans are deeply concerned about rising crime. They saw it last year, and with the riots that were held across this country, it sent a clear message to people, some who have taken advantage of that message, that, you know what, law enforcement's backing down. And that is exactly what's happened. In fact, you can see how the message is resonating with the populace, rather than, as I term, the loud minority, by what happened in the New York City mayor's primary race, where you had someone with law enforcement who received the most votes. And I think you're going to see more of that, because it is average Americans that see the horrible effects of rising crime across America, and Americans are not going to accept that for long. And my colleague from Texas referred to the pendulum a little bit earlier. I would just say, make sure that we're funding law enforcement. Make sure we're giving law enforcement the respect that they deserve, that we're giving them the tools that they need to have, because we need someone that is going to stand up for victims, someone who is going to take the bad guys and make sure that they're going to be sent to jail and prosecuted. Otherwise, we're going to see that pendulum swing back, and what you saw back in the 1980s could repeat itself again in the not-too-distant future. If you want to save lives, if you want to make sure law enforcement have their tools, you will vote for this amendment. I yield back, Mr. Chairman.
The gentleman yields back. I recognize myself in opposition to the amendment. This amendment has nothing to do with this bill. The bill is talking about reentry centers for veterans. The amendment is talking about the merits of defunding a police department. And the gentleman quite correctly points out that the electorate in New York City, at least in the Democratic primary recently, supported the candidate who favored greater spending on the police, but maybe next year they'll support a candidate who wishes to change some of the funding from the police department to the fire department, because they have a lot of fires or whatever. That's up to the people. And in any event, has nothing to do with this bill and shouldn't be in this bill. It's a distraction, and I oppose the amendment for that reason. I yield back.
Mr. Chairman.
For what purpose does the gentleman from Ohio? For what purpose is the gentleman from
Strike the
Ohio
last
seek
word.
recognition? The gentleman is recognized.
Yeah, I support the amendment. I mean, this is about public safety. That's what this bill is. We both talked about reducing recidivism rates, public safety. This is about this is a fundamental issue that is one of the key debates in our culture, in our country today. And we all know what has happened to every single major urban area in this country as police forces around the nation have been defunded. So it's a straightforward, simple amendment, makes sense, good common sense, something we should keep the bipartisan approach that has been evident here today and been in practice here today. We should keep that in play and support this amendment. It's a good amendment to a good piece of legislation. I would yield the balance of my time to the gentleman from Wisconsin.
I just want to say thank you to the gentleman from Ohio for yielding. So the term was used by the chair that this is a distraction. You go tell that to the people in Minneapolis. You go tell that to the people in New York City. You go tell that to the people in Portland, a beautiful city that is now becoming the Beirut of the West Coast. Just talk to people who have been there to Portland, because I have, and they're seeing the harmful effects of crime. And all this bill does is make sure that those dollars are spent by law enforcement. It's a simple maintenance of effort provision. There is nothing wrong with adding this to this bill. We see these, when I sat in the state legislature, we saw maintenance of effort provisions all the time from the federal government. And this is an appropriate one to make sure that we're funding the police. And this goes right back to the difference between us and the other side at this point. Are you going to stand up against rising crime or not?
Well, the gentleman
You're going to have to make a choice here. Are you going to stand up against rising crime, and are you going to stand with the police? Because
the gentleman yield.
Just 1 second. This makes sure that resources are not taken away from police departments, because I've seen the actions from places like Minneapolis and other cities where they're making it clear yet they want to defund the police, and they'll find any way to do it. And we should not allow them to take federal money that's going to be authorized with this bill and backfilling it with money that they pull away. Let's make sure that that does not happen. I yield to the gentlewoman.
Thank you. I am confused, because I know that you are expressing tremendous concern about defunding the police, but my confusion is that my colleagues on the other side of the aisle that were concerned about defunding the police also voted against the rescue plan that provided billions of dollars to local governments so that they could fund the police. So why is it that you are concerned about this bill, which has nothing to do with funding the police, has everything to do with preventing crime by making sure that people who come out of prison can successfully reintegrate and have jobs and not commit crimes?
I reclaim my time. So thank you for your comments from the gentlewoman from California. And yes, we want good reentry programs. We want people to get that rehabilitation. That's really important. I voted for those things, like drug courts and others. When I was in the state legislature in Wisconsin, I understand how important they are. But you ask why we put this here. Because now is the place and time.
Why you voted against the rescue plan?
Now is the place and time. Now is the place and time to deal with this. We have a bill before us. We want to make sure, or this amendment will make sure, that we do not have a city or any municipality across the country somewhere that wants to take this money and backfill. And because there are sometimes some clever bean counters in some of those municipalities that they choose to do such things. Let's make sure that the money that's going to be going for this program, that it doesn't go for other purposes, and that we make sure that our law enforcement is able to retain the money that's been allocated to them.
Mr. Tiffany, will you yield for a question?
As we go forward.
Mr. Tiffany, will you yield for a question?
I yield back the balance of my time to the chair.
The gentleman yields back. For what purpose? Does the gentleman from Rhode Island, Mr. Cicilline?
I move to strike the last word.
Gentleman's recognized.
I want to just associate myself with the remarks of Congresswoman Bass. This has nothing to do with this bill, but I would make one point about the consequences of this amendment, which I'm sure Mr. Tiffany doesn't intend. But I was mayor of the city of Providence, and we created this highly effective and now nationally recognized program where we partnered with a community-based organization on the issue of domestic violence, and experts in domestic violence prevention actually ride with police officers to arrive at the scene of a domestic violence call so they can immediately interact with the victim of domestic violence, particularly children, because of the trauma that children experience while someone's being arrested and the police arrive at their home. It's an incredibly effective program, one which the police helped create and strongly support. And so the Providence Police Department allocates some resources to that agency that does this work. And I think your amendment would say they would no longer be eligible, because it says defund means, with respect to any police department, that the budget of such a police department is reduced for any reason. This was reduced for a really, really good reason. One the police wanted and supported, that reduced crime, reduced the trauma of domestic violence, made response to domestic violence calls safer. So I get that you're trying to raise this issue of defunding the police. That has nothing to do with this bill, but even the way it's drafted, it would prevent the kind of community police partnerships that are so critical in reducing crime. So I urge you to withdraw your amendment so we can get back to Congresswoman Bass's excellent bill on reentry. And
But would the gentleman yield?
of course, I'll yield to the gentleman from Maryland.
Well, I want to thank the former mayor of Providence, Rhode Island, our distinguished colleague, Mr. Cicilline, for pointing this out. This is what jumped out at me immediately. This amendment is a radical assault on federalism and the right of state and local governments to manage their own budgets. It's defining defunding, and I understand that that's the word of the hour, and so the whole point is to try to inject political rhetoric into this, but it defines defunding as any reduction of any amount. It could be $1,000 in a police budget for any purpose at all other than reflecting a decrease in revenue. Why would we try to micromanage the budgets of tens of thousands of jurisdictions across the country in this way, all to make a political point? If you want to demonstrate your support for law enforcement, I understand that you do, then please go meet with Officer Fanone, meet with Officer Dunn, meet to the law enforcement officers who saved our lives against the worst violent assault on the U.S. Capitol in our lifetimes, with domestic terror groups involved in it. And we understand that there's an attempt to make up for the failure of a lot of people to support law enforcement in this context, but this is a bad way to do it. I yield back to the gentleman.
Yield back, Mr. Chairman.
Gentleman yields back. For what purpose does Mr. Bishop seek recognition?
Thank you, Mr. Chairman. Strike the last word.
Gentleman's recognized.
I thought I would comment very briefly on the gentlewoman from California's point, suggesting one of the most amazing contentions in modern political discourse that I've ever heard is that members of the Republican Party who did not support the $1.9 trillion Christmas tree earlier this year that did almost nothing for COVID relief were in the process, did by that vote defund police. One of the things that came out after that notion was popularized by Democrats and their allies in the media is that there's no mention of police in the entire legislation. The possibility on which this premise rests, apparently, is that some of the money that was spewed around and has resulted in inflation in which the price of milk and eggs is up for every American, a tax increase, a regressive tax increase on Americans in every way, that result has occurred. But the notion that there could have been something connected to police is that some of that money could have been used by somebody to augment a police budget. It is almost as if the members on the other side do not know how police are paid for in this country. Policing is a local government function, and Democrats across the country since last summer, including members of this body, have repeatedly called for police to be defunded and or abolished. That is the issue to which Mr. Tiffany's amendment speaks, I believe, and the notion in response to that Republicans are trying to defund the police is almost, I don't know whether it's funny or clueless, but it's one or the other.
Mr. Biggs, will you yield, and maybe I can clarify for you?
Well, let me...
I'm sorry, Mr. Bishop. I know Mr. Biggs would never make a comment like that.
Mr. Tiffany had asked for me to yield to him, so I'm going to yield to him. If he's got time, I'll yield to Mr. Cicilline. Mr. Tiffany, I yield to you.
Yeah, thank you for yielding, Mr. Bishop. So just a couple things. We just heard in regards to the assault on the Capitol, and I can understand why the gentleman from Maryland may not be familiar with it, but I was there in 2011 when there was a 3-week assault on the Wisconsin State Capitol when people were hunkered down, bedded down in the Wisconsin State Capitol. I've seen it before. So, and also, I heard this thing about a radical assault on local government. When I watch it, I mean, in just a little over a year that I've been here, as I read these bills and stuff like that, I mean, talk about an assault on local government. I mean, we are sending down mandates and requirements and all kinds of stuff that are just simply constant. I mean, when I sit in the other committee, I'm on natural resources, I just see it constantly, how the federal government is dictating to local governments. So to hear that there's this radical assault on local government, that this is I think that's rather disingenuous. I'm not going to withdraw this amendment. I think this is a really important amendment to make sure that police are funded appropriately across our country, even if they don't, some people don't want to do it, especially in our big cities of the United States. I think we need to continue to fund the police. And if you're serious about crime, as the American people are right now, because just talk to the American people at this point, this is one of their top 3 issues, especially if you're in the cities. They are tired of the crime, especially the violent crime. I mean, we've seen the statistics, the increases. I mean, just a few months ago in Minneapolis, what was it? Carjackings are up over 300%. I mean, those type of crime statistics we are seeing across the country. This protects funding for the police and hopefully gets us to a place where we have less violent crime that is happening in our country because it's out of control right now. I yield back to the gentleman from North Carolina.
And before I yield a few seconds to Mr. Cicilline, I would say that one thing that for those who would suggest, as I've mentioned earlier, the absurd notion that voting against the $1.9 trillion big spending bill meant you're against police, it's really simple to decide whether you're for or to signal whether you're for or against police by voting for this amendment. And if you vote no, everybody knows, very clear. I yield to the gentleman from Rhode Island.
I thank the gentleman for yielding. I just would make the point to amplify Congressman Bass's point. We appropriated $350 billion to state and local government in the Coronavirus Relief Fund. The Department of the Treasury specifically said law enforcement was eligible for that funding because of the rise in crime during the COVID pandemic. So you can say you support the police, but we should judge you by your actions. You voted against $350 billion, which could be used to fund local police departments. I know the cities and towns that I represent, they'll be using some of that to support law enforcement. So it's easy to say you're for the police, but in the moment when you were tested, every single Republican voted against funding the police. That's Congressman Bass's point, and I yield back and thank the gentleman for extending the courtesy.
The gentleman's time is expired. What purpose does Ms. Deming seek recognition?
Move to strike the last word.
And ladies recognized.
Mr. Chairman, are we at this again? Are we really doing this yet again? We all have a lot of things to say, but I would prefer to look at what you do. You're sitting here yet again. Mr. Chairman, they are sitting here yet again, talking about supporting the police, funding the police, when they voted against the opportunity to fund the police when local governments were screaming for help and the American Rescue Plan would have helped them. Didn't support the police then. Secondly, when the police were being attacked, it's not what you say, what you do. on January 6th, and you had an opportunity to vote in favor of an independent commission that would have gotten to the bottom of it and held every criminal accountable, not just the ones who, the 550-something who were arrested for attacking the police, but those who incited it, those who inspired it, those who funded it. And you chose not to do that. You know, let me tell you about the heart of a good police officer, because I believe there's a little lesson that needs to be taught here. There's nobody more dedicated, and as a former officer, to protecting and serving our communities, but we don't pick and choose as law enforcement when we want to do that. Good police officers do their job well, but you know what? They're also very supportive of programs just like this, because they understand you hold the most violent criminals accountable, but you also work to address the quality of life issues that plague communities in the first place. So here we are again with rhetoric. You support the police, don't pick and choose the moments that you want to do that. Support police all the time. Mr. Chairman, I yield back.
The gentlelady yields back. For what purpose does Mr. Shabbat seek recognition?
Move strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I think what you're seeing here is kind of desperation. My Democratic colleagues are desperate. It's so clear. They're in trouble. They know they're on the brink, on the verge of losing the House.
Oh, here we
and
go.
Control of this committee in the relatively near future. And one of the key issues that they're losing, they've lost the American public on, is support for the police and the crime that's rampant across the country, particularly in our cities. And so the gentleman from Wisconsin here has offered, I think, a perfectly legitimate amendment that we'll see on this vote how it goes down. My guess is all the Republicans will vote for it, support it, and I think all the Democrats will vote against it, even though they'll say they support the police, but they'll vote against it. And let's, again, look at this amendment. It basically says if a community defunds the police department, they're not eligible for grants under this program or this fund or this bill or this section. So you defund the police, you don't get any of this money. It's perfectly clear. And we'll see on the vote which side members ultimately fall. And now they're trying, because they are so desperate and understand that they're in trouble because their support for the police, I was going to say, is being questioned. It's really not being questioned. And it's not every Democrat. Well, we'll see how they vote. But it's not every Democrat, but there certainly are Democrats who want to defund the police.
Would the gentleman yield?
Well, I'm on a roll here.
All right.
So well, if I have some time left at the end, I will. So the Democrats, as I say, are desperate. And so they've thrown back, and Ms. Bass is a good friend of mine, and I respect her tremendously. We worked here on a whole range of issues. She's great. But she's also indicated that, well, to Republicans, well, you voted against this one bill, and therefore you voted against funding for the police. And they're talking about this so-called rescue bill or the COVID relief bill. Now let's look back before that. In the last Congress, where Democrats controlled one house, they controlled the House of Representatives, Republicans controlled the Senate, so it had to be bipartisan. So when we were dealing with COVID around this place, it was bipartisan. We passed the CARES Act and a whole range of bills that were bipartisan. We had the PPP program. I was the lead Republican on the House Small Business Committee at the time, and we saved a whole bunch of jobs all over the country because of that program. There's a lot of other good stuff in there. They were bipartisan bills. Democrats took over both houses as a result of the last election, and so they didn't have to be bipartisan anymore. So they had this almost $2 trillion bill that was a so-called COVID relief. That's what it was called. COVID relief bill. 9% of the money in there went for COVID relief. And this money that they were giving out to cities, for example, could be spent for anything. As my colleague from North Carolina, Mr. Bishop, said, there's not a word in there about police. And they're saying, well, maybe the police could have got some of that, but it wasn't in there. We know that it was given cities to do whatever the heck they wanted to, and states that got in financial trouble because of bad decisions, huge amounts of money for that. And yeah, I think all the Republicans voted against that huge boondoggle bill that wasn't bipartisan, and now they're saying, because they're so desperate, that, oh, Republicans are against the police. We'll see what the public, the way they look at this. Which party is more for the police, Republicans or Democrats? There's no question in my mind. That's why they're so scared on this issue. When we talked about protecting the police, look at, in this very committee, the qualified immunity debate. They wanted to take away basically the little protection that police officers have. They wanted to allow them to be sued personally. Your personal assets. Who's going to want to become a police officer if they can go after your kids' college funds or your pension? Stuff that basically is for your family because you've violated some rule and you may not even have known it. You may have followed police policies. They were willing to put the police in that kind of jeopardy. That was their answer to the instability that we saw a couple summers back. So I would just conclude here, because I'm about running out of time, that there's no question which party is supportive of the police and trying to do something about this out-of-control stuff that's going on all over the community. And defunding the police almost happened in my community in Cincinnati. They had on the ballot there to take $50 million from the police and give it to so-called affordable housing. And that's the kind of thing this is all about. So thank you for offering this amendment, and I'm out of time. I yield back.
The gentleman yields back. For what purpose does Ms. Dean seek recognition?
Mr. Chairman, to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I rise to oppose this amendment, and it is a striking amendment in the use of the language, any local government that moves to defund the police. If somehow those on the other side of the aisle were among that list of those who defund the police, you would be disqualified as a result from the funding. Let's take a look at what really happened over the course of the last year or so. Following the insurrection, many in the conference on the other side of the aisle would not meet with Capitol Police. Not a single member of the Republican conference voted for support for state and local government, which every one of our municipalities, boroughs were crying for. And unfortunately, I will say, Democrats got it done, and $350 billion has gone out to state and local governments to support the very people who keep us safe. That's called funding the police. We passed a security supplemental for Capitol Police in desperate need of resources. The great majority of your members voted no. You wanted to defund the Capitol Police. They now remain at risk of not being able to pay salaries, let alone beef up the support that they need that General Honore spoke about. And finally, most shamefully, 21 of your members couldn't bring him or herself to vote in favor of the recognition of the gold medal for Capitol Police, who literally saved every one of our lives. And so I rise in opposition to this reckless, fear-mongering amendment that is not based in fact or truth. I do lend my support for the underlying legislation, the One-Stop Shop Community Reentry Program. This is a common-sense piece of legislation to address the challenges of millions of Americans who are thrown into a vicious cycle that scholars have labeled a revolving door to prison. This year alone, we have spoken multiple times of our broken criminal justice system. Again, more than 2 million individuals are currently incarcerated, but we don't discuss that over 95% of those who are incarcerated will eventually be released back into our communities. What are we doing about that? What are we as a body doing to represent these Americans so that they can become active citizens again? Current law makes it impossible to find work, find health care, find a home. And this is wrong. This is America. We know this is wrong. I commend Representative Bass on addressing this issue through the holistic legislation The bill streamlines the services that have been proven to decrease recidivism rates. In the United States, formerly incarcerated people are almost 10 times more likely to be unhoused than the general public. This is a bill that goes beyond rehabilitation and services. It goes to acknowledging the humanity of formerly incarcerated people. We have a duty to give people returning to society a fighting chance at reentry and regaining their families and their lives. After someone serves his or her time, he or she should not be punished in perpetuity. This bill takes a logical step to address the exact issue. I urge all of my colleagues to support this legislation and encourage us to consider and yield the balance of our time in order to do such work. Again, defunding the police, sadly, is the response to by the other side of the aisle. It is not the response here. And I yield back.
Gentlelady yields back. For what purposes does Mr. Biggs seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you so much. I'm actually kind of getting a kick out of it because I'm beginning to think people really believe the rhetoric that the Republicans voted to defund the police by voting no on this monstrosity spending bill. But you know what? Our loyal supporters in the media, those people who always support us, Republicans and conservatives in the media, the Washington Post, wait a second, I got that backwards. But even the Washington Post said, Democrats, three Pinocchios on you for saying that by voting against that bill, that was a defund motion. The Post, Salvador Rizzo, wrote, although Republicans all opposed Biden's coronavirus relief package, no one voted to cut or defund anything. So you can spin that all you want, but it's simply untrue. And the reason that you all are saying that is because you passed a bill out of here earlier on. Did two things. Moved hundreds of millions of dollars out of policing into filing federally mandated reports, moving it from normal police activities so you can get more reports and information, distract them from the job of policing that they want to do. And in that bill, you threw in elimination of qualified immunity. That's a big deal. So let's just see here. President Biden said he supported reallocating police resources. The vice president said, I applaud Eric Garcetti for defunding the LA police. We have to reimagine public safety. Biden's Associate AG General Vanita Gupta said officials must heed calls to decrease police budgets. Boston Mayor, Biden's Secretary of Labor, Marty Walsh, when he was mayor, proposed a budget to divert funding from law enforcement. A member of this own committee said the Minneapolis City Council, quote, it was very thoughtful for voting to dismantle the police. The Speaker, fellow Democrats refused to criticize the Minneapolis City Council that did defund police when they were given the opportunity to. Another member of our body said protesters need to get more confrontational with police. Another representative from the other side of the aisle called for dismantling the Minneapolis Police Department, and a member of this committee called for defunding police. And recently, in the last 2 weeks, we've had two members of not this committee, but this body from the other side of the aisle. One stood by her calls to reallocate resources away from police, saying that a reaction to that based on crime is just, quote, hysteria. Another said she still supports defunding the police. Let's not spin this away from what it is. Here, how about some cities? Maybe this will help you understand. Cities that have defunded police: Austin, $150 million cut. Baltimore, $22 million. Boston, $12 million. Burlington, Vermont, $1 million. Columbus, $23 million. Denver, $55 million. Eureka, California, $1.2 million. Hartford, $2 million. LA, California, $175 million cut. The only time I've actually agreed with the sheriff of LA County. He came from Arizona. He went from Arizona over to LA, and I've seen his career when he was belly aching recently. And what are the things well, that's kind of where I am too. But one of the things I thought that was so interesting about it is he brought up the defund police movement in LA. Madison, Wisconsin, $2 million. Minneapolis, $8 million. New York, $1 billion. Norman, Oklahoma, $865,000. Oakland, California, $14.6 million. Oklahoma City, $5.5 million. Philadelphia, PA, $33 million. Portland, $15 million. Salt Lake, $5.3 million. San Francisco, $120 million. Seattle, 69 million. Steamboat Springs, 1.5 million. Washington, D.C., 15 million. Total $1.73 billion cut. What do they all have in common? They're not led by Republican mayors or councils. How about that? Does that spin enough for you? I got another laugh when someone talked about the independent commission regarding January 6th. It is so independent that Nancy Pelosi has control of the membership of that committee and said, and she booted off 2 of our members. That's independence for you. That's fair. That's getting to the bottom of things. I'll tell you what, when I hear the revisionist history coming from across the aisle today on this, it's outrageous. That gets us to the point of where we sit.
Would the gentleman yield?
No, I'm finishing it. I got 18 seconds. Otherwise, I would. I got 18 seconds. I got to finish up here. I support this amendment. It's rational. It makes good sense. It's tied to what we're trying to do here today. And with that, Mr. Chairman, I yield back.
Gentleman yields back. What purpose does the gentlelady from California seek recognition?
Move to strike the last word.
Lady's recognized.
Yield to you.
Thank you. Thank you. The gentleman spoke of why Nancy Pelosi didn't let the Republicans have the people they want on the commission. The fact of the matter is, you gave her that right. You gave it to her. You could have had an independent commission. Remember, there was an independent commission set up that the Democrats wanted, with an equal number of Republicans and an equal number of Democrats, and the Republican Senate voted it down. So we had to set up a select committee, and in that select committee is an unequal number, and the Speaker has choices. But you gave her that choice because you refused. By you, I mean the Republicans, not you, Mr. Biggs. You, the Republicans, set up this situation by voting down the independent commission, which would have had an equal number of Republicans, an equal number of Democrats.
Would the gentleman yield for a question?
And a moment. And the Speaker would not have had any power of choice. I will yield to.
He can't, you can't yield.
Will the gentlewoman yield for a question?
I reclaim my time.
Will the gentlewoman yield for a question?
I will yield to Representative Cicilline first.
I thank the gentlelady for yielding. I've spoken on the amendment, so I'd like to spend a moment to get us back on track and talk about the excellent piece of legislation before us. I want to thank you, Chairman Nadler, for holding this markup, and thank you to Congresswoman Bass for her extraordinary leadership in sponsoring this necessary bipartisan and bicameral legislation that gives formerly incarcerated people a fighting chance at success upon release. Every year, roughly 600,000 people in the United States are released from state and federal prisons. Though no longer behind bars, in many ways, their sentences continue. A victim of sexual abuse who served time for drug-related charges should have the opportunity to find safe, affordable housing and substance abuse treatment upon release. A person suffering from mental illness who was convicted of a low-level drug charge should have the opportunity to find a job to support their family. According to a March 2020 report by the Prison Policy Initiative, most crimes committed in the United States are misdemeanors or non-criminal violations, not serious or violent crimes. Low-level offenses like technical violations of probation and parole often lead to incarceration and additional consequences. But instead of investing in community-driven safety initiatives, many cities and counties continue to spend inordinate amounts of taxpayer money on incarcerating people for minor offenses. I mentioned earlier I served as mayor of Providence. During that time, I assembled a reentry council that brought together community leaders, housing experts, religious leaders, business folks to help formerly incarcerated individuals transition back into the community safely after they completed their sentence. During my time as mayor, I saw how increasing access to reentry services helps reduce the likelihood that people will return to prison. Comprehensive reentry services, including food assistance and access to employment opportunities, help to ensure that justice-involved individuals have the support they need to provide for themselves and their families and to be productive members of their communities. That's why I'm proud to support this legislation, which provides grants to community-based organizations and other eligible entities to create community reentry centers. There is currently no agency responsible for helping people who are released from prison with obtaining essential services or overcoming the stigma of incarceration. The One Stop Shop Community Reentry Program Act incentivizes community-based solutions for accessing housing, education, employment, and healthcare. It also assists with reconnecting returning prisoners to their families and neighborhoods. The resources and services offered include everything from help with obtaining an ID or driver's license to referrals for legal assistance or family counseling to facilitating treatment or access to healthcare. This legislation removes barriers to essential services for successful reentry. It seeks to end the revolving door of recidivism. It helps people navigate life after prison. And importantly, it makes our communities safer. It gives people a second chance. I urge my colleagues to support this bill, and I thank Congresswoman Bass for her really strong leadership on a piece of legislation that is going to make our communities safer and lead to many more individuals leading productive, healthy, law-abiding lives. And for that, our nation owes her a debt of gratitude. I yield back.
For my colleagues on the other side of the aisle that have raised repeatedly the rise in crime, this bill specifically addresses that issue by successfully reintegrating people back into the community so that they won't reoffend. Providing them access to jobs, access to housing is a way to reduce crime. So I would ask for their support, and I would also ask that we get back to the issue at hand and vote for this bill. I yield back.
Gentlelady yields back. For what purposes Ms. Fishbach seek recognition?
Mr. Chair, I move to strike the last word.
Gentlelady is recognized.
Mr. Chair, first I'd like to associate myself with the comments of my colleague from Arizona, and particularly my colleague from Ohio, who did talk about the COVID relief package that the Democrats are saying was our vote against, was the Republican vote against police officers. But I do want to just yield to my colleague from Wisconsin, who is the author of the amendment, to talk a little bit more about it.
Thank you. Thank you to the gentlewoman from Minnesota for yielding. So the question was posed, are we at this again? And I would just say that and what I've seen here in 2021 is we get rare chances to amend bills. I think about some of the other committees that I'm in. We see stuff that just goes straight to the floor, not going through regular process. I don't have any examples immediately offhand, but that's been striking to me over the last couple months that you'd like to propose an amendment, but boy, that bill's going straight to the floor. And what I hear from committee chairs is that, boy, this is so urgent, we just have to get this done. So when we do get an opportunity to offer an amendment, I think it's very important to do it. And this was the one time that I could get an amendment in regards to a maintenance of effort provision. And by the way, to the author of the bill, I know her intentions are genuine and sincere. There's no question about that. I'm not questioning that at all. What I'm saying is that this is an opportunity to make sure that we don't have cities that are going to be defunding their police. And I believe the American people, agree with that. And I will go back to the comments I made in my original remarks. Crime is rising in our country. It is. And the pendulum swings, and you're going to jeopardize the gains with the First Step Act and things like that if we don't make sure we have good policing in our communities around America. And that's why an amendment like this, while it's small in the scheme of things, is really important to make sure that we're sending a message also that we in Congress want changes in policing, we want some changes in law enforcement and things like that, but by gosh, we do want public safety to continue to be preeminent because it is one of our number one duties is to make sure that we're providing for the public safety. So this amendment is given to you sincerely, and I believe if you want to make sure that the police are funded around our country, which I believe most of us do, this is a really good amendment. We see maintenance of effort provisions that are put in bills regularly. While I'm not a big fan of them oftentimes, I think this is an instance when it comes to public safety where maintenance of effort is appropriate. And I yield back and thank my colleague from Minnesota.
Thank you. And I,
The gentleman yields back. Oh, I'm sorry.
Mr. Chair,
I yield it back to.
yeah. Mr. Chair, I yield the remainder of my time to my colleague from North Carolina.
I thank the gentlelady. You know, I think one other point needs to be made. Mr. Biggs did a fine job of reciting the Post's calling out this rhetoric that Republicans had not supported police by virtue of not voting for the massive COVID bill, the 1.9, which said it was a COVID bill, but it wasn't even that. But I think there's another point that serves to be made. The question of funding police is not one, those who have defunded police across the country did not do so because of the availability of money or its lack. Rather, they did it for ideological reasons. They did it because they believe, they articulated a belief that that was the way to make things better. The gentlewoman from Michigan in this body said, end policing. That's what she said. And I understand why that produces desperation on the other side. Because, and you will run in every direction that you can because you are simultaneously seeking to accommodate that abominable ideological notion that every American knows is wrong, everyone with common sense, and at the same time, try to sell the American people on the fact that you're not doing exactly that. That is the problem. It's a matter of life and death. 10% cut in Portland, 553% increase in murders. People are being killed. The games should stop. I yield back.
Gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
To strike the last word.
Gentlelady is recognized.
Last week in my district, I stood with the Houston Police Department in very emotionally and sincerely as we presented them with almost $1 million to deal with crime victims. Of course, we would like not to have crime victims, but we did have a crime victim there who said, thank you for caring about them. Thank you for caring about crime victims. I would imagine that there are Democrats across this land who interact every day with their police officers. And so I take umbrage and offense of any sort of characterization. I do want to emphasize what I believe the gentlelady from California's bill is all about. In a research question given to individuals who are coming out of prison, 67 men, 18 to 66, what they wanted in life was what most Americans say they want: to be able to own their own homes, drive nice cars, take their families on vacation, among other things. Several wanted to be doctors and lawyers, prestigious careers by American standards. Many also said they wanted to give their children opportunities that they hadn't had, like the chance to go to a prestigious college. This bill is about those opportunities. Can we not see plainly and clearly what the intent of the gentlelady's bill is, the one-stop shop community reentry program, and particularly the hotline, so no matter what rural hamlet you're in, you can access what can I do to become a doctor or a lawyer or own a home or to treat my children fairly or to give them the blessings, as Barbara Jordan said, of this nation, the promise of America. Further, in a report that has come to my attention, that the first estimate of homeless among 5 million formerly incarcerated people living in the United States, this report, finding that formerly incarcerated people are almost 10 times more likely to be homeless than the general public. You break that down, this data by race, gender, age, and other demographics, and it becomes even more severe. This is what this legislation is about: to be able to treat individuals who've done their time with dignity, to be able to say, yes, you can have that dream, that American home. You can have the best for your children. And so when we enter an amendment, then I'm going to speak to the technical aspects of it. I don't really understand what defund means, because what is the definition of my friends? And then I'm not sure if this has been made, but they're now interfering with states' rights, and I thought they were truly states' rights individuals. They're interfering with decisions made by law enforcement officers in individual states. They're making a federal fiat of how you run your police departments. that may want to be merciful, may want to be humane in the way that they treat the issues of crime. We all are outraged by crime in America. All of us are outraged by this crime. We cry for the victims, but we also understand what is necessary to do good policing and good reform. This is a reform bill. And I'd venture to say that law enforcement persons on this panel would celebrate reform, would celebrate trying to deal with ending recidivism. I want to end recidivism. And I do want to say to my friends, on January 6th, there are probably many people that are not in this Congress that are suffering from post-traumatic stress disorder, and they are our officers that were on the front line. I'd like to think that we are more concerned about ensuring that that never happens again, that we will not ever call that a tourist trip, people taking cameras with their Kodak paper cameras, taking pictures, while someone's head was squeezed into the door, pleading for his life, or beaten to his death, almost a gun taken out of one officer. That is what we should be speaking against. But an amendment, all well-meaning, I'm sure the gentleman is well-meaning, I cannot support it because it doesn't even define what this means. And I cannot support it when law enforcement persons are asking for reform and victims are asking that people who are recidivists, that we stop that, and that the bad guys are the bad guys, and those who are seeking a new life are being helped by the gentlelady's legislation. That is what I think we should be discussing, and I might, as I end, say thank you for a bipartisan discussions that we've had of the other bills. I appreciate it, and I'm hoping that we can do so here and understand the complexity. I just want to submit into the record, post-prison, people just want normal things. Americans say that's too much to expect, but we are seeing what they want, ask unanimous consent, and then a prison policy institute, nowhere to go, homelessness among formerly incarcerated persons. I ask unanimous consent to submit these into the record.
Without objection.
And I ask support for the bill. I yield back. Thank you.
Gentleman yields back.
Mr.
For what
Chairman,
purpose does Ms. Sparks seek recognition?
I move to strike the last word.
Gentlelady is recognized.
I yield my time to the gentleman from Wisconsin.
Okay, thank you very much for yielding. And we saw some pounding on the table here, outraged by crime, yet we have somebody in this body who just in the last week or two said we should not only defund the police, but we should defund the Border Patrol, we should defund ICE. I mean, anything that serves as protection for the American people, I guess that person is advocating, that person who is in this House of Representatives is advocating for defunding. And the American people hear that. And also, people who are perhaps choosing a life of crime, that they also hear that message too. And you're seeing our cities overrun. I mean, you look at what's happened in California with no cash bail and things like that. I mean, you've got companies like Target and others. I mean, you see the stories. They can't even open their doors anymore. I mean, what is it, $1,000? You can shoplift up to $1,000 and you just go right back out on the street? I mean, that stuff, it is simply craziness. And the American people are saying, hey, we got to make sure that our police are funded. This has gone too far. And I'll go back to what I've said twice before now. You're going to jeopardize the gains for the First Step Act and some of those things that you see as progress in regards to law enforcement in our country and how law enforcement reacts, because the pendulum is going to swing back. And this bill, or excuse me, this amendment is just a simple effort with the opportunity that avails us, because it's so rare when we see bills that go straight to the floor. This is an opportunity to make sure that police continue to be funded as they should be. And I can tell you, you go to these municipalities around America, and I'll bet you they'll tell you that they support this amendment. And that's why I brought it forward. And I understand the intent of the bill. I think it's genuine. I think it's sincere, as I said before. And, but this amendment is also, but most importantly, it is important for public safety in America. I yield back to the gentlewoman from Indiana.
Thank you for yielding back, and I yield my time to the gentleman from North Carolina.
I thank the gentlelady. And one more point needs to be made, I believe. The chairman spoke to the question, well, I guess in a fairly elongated logical chain, or a chain that appeared to be intended to be logic. There was a reference to the failure of Republicans to vote for the so-called bipartisan commission to examine January 6th. Well, I offered one of the objections to what was proposed on the floor myself, and that was that contrary to being a bipartisan commission, the staff was to be controlled by the majority. And anybody who spends any time here for long understands that that means the work of the commission would be controlled by the majority. It would be bipartisan only in a patina, only in appearance. Now, to those who had a suspicion about that, the other side thought that was horrific that you would even think that. So now there's a select committee in which the appointments are made by the speaker, and the way things always work around here for members of the public who don't know is that the minority gets to, the minority leader gets to suggest nominees for the minority. And that's what Mr. McCarthy has done, and now the speaker has rejected the ranking member on this committee, Mr. Jordan, and Mr. Banks from Indiana, who, and among other things, chairs the Republican Study Committee. Now, what I understood the chairman to say just a moment ago is she had to do that because it's no longer a bipartisan committee? You mean because it's now a select committee chosen by the speaker, she must act in a partisan way? Doesn't that validate the skepticism that members of the minority had when voting on that so-called bipartisan commission? That once the power is vested in the speaker to decide, what did she do? She takes a rank partisan action. The exclusion of members of the minority from participating on a committee. You guys are headed down the slippery slope so fast it'll make someone's head spin. The last thing that you've done is preclude Marjorie Taylor Greene from being on a committee because she had comments before she was in Congress. And now respected, highly members with unquestionable integrity in this Congress are being precluded by the speaker from participating because she's compelled to act in a partisan way, I suppose. The time's exhausted. I yield back.
Gentleman yields back. Does anyone else seek recognition on this amendment? If not, me too. If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no. No. The noes have it. The ayes and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen?
It is no coincidence that the urban heat island effect is
Mr. Johnson of Georgia?
the same. Have been
Johnson votes aye. Oh, excuse me, votes nay.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries?
No.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
McBath votes no.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar? Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes yes. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens?
Owens, yes.
Mr. Owens votes yes.
Mr. Chairman, how am I recorded? It's Raskin.
Mr. Raskin, you are not recorded.
I vote no.
Mr. Raskin votes no. Mr. Cicilline, you are not recorded. Mr. Cicilline votes no.
Are there any other members who have not been recorded or wish to be recorded? Clerk will report.
Recorded? How am I recorded?
Mr. Gates?
Mr. Gates, you are not recorded.
I'd like to vote aye.
Mr. Gates votes aye. Mr. Chairman, there are 14 ayes and 20 noes.
The amendment is not agreed to. Are there any other amendments to the amendment in the nature of a substitute? Hearing none, a reporting quorum being present, the question is... Thank you. A reporting quorum being present, the question is on the motion to report the bill H.R. 3372 as amended favorably to the House. Those in favor say aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. The yeas and nays have been requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes yes. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia?
Johnson of Georgia votes aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass?
Aye.
Ms. Bass votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Demmings? Ms. Demmings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Isa?
Aye.
Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana?
Aye.
Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach? Ms. Fishbach votes no. Ms. Spartz? Ms. Spartz votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz?
Yes.
Mr. Benz votes yes. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Mr. Deutsch?
Aye.
Mr. George votes aye.
How is
Mr.
Swalwell
Swalwell?
recorded?
Mr. Swalwell,
Aye.
you're not recorded.
Aye.
Mr. Swalwell votes aye.
Mr. Chairman, how am I recorded? This is Ken Buck.
Mr. Buck, you are not recorded.
I vote no.
Mr. Buck votes no.
Are there any other members who wish to be recorded who have not been recorded? The clerk will report.
Mr. Chairman, there are 31 ayes and 8 noes.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 4435, the Fight Notario Fraud Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4435, to amend Title 18, United States Code.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. The Fight Notario Fraud Act of 2021 would criminalize the practice by unlicensed and often untrained people who offer legal services in immigration matters to unsuspecting victims. Last Congress, we passed a nearly identical version of the bill out of this committee and through the House on a bipartisan voice vote, and I hope we will do the same again this year. The bipartisan nature of last year's vote speaks to the widespread condemnation of these fraudulent practices. Notario fraud grifters take advantage of the translation of notario publico in Spanish to notary public in English. While the translation may be technically accurate, the meaning is very different, and the intent of these scam artists is malevolent, to defraud unsuspecting patrons seeking immigration help. In Latin America, notario publico often refers to a licensed attorney, whereas in the United States, a notary public is only permitted to witness the signing of documents, not to act as a lawyer. But many immigrants, particularly Latinos, unfamiliar with the American meaning of the term can be fooled by fraudulent notary publics into seeking legal assistance on immigration matters, often with disastrous consequences. Many of these immigrants may lose thousands of dollars and their immigration applications may go nowhere. But they are lucky compared with those whose immigration cases are irreparably harmed and whose opportunities to normalize their immigration status are prejudiced or even lost. Notarios may also abandon their victims and flee with important documentation that immigrants need to file for immigration relief. Victims of notario fraud who have entrusted these fraudsters with their future and their hopes are both ripped off and potentially stripped of the opportunity to pursue the American dream. To address the prevalence of notario fraud, the Fight Notario Fraud Act would create 3 new federal crimes. First, it would outlaw the provision of fraudulent immigration services. Second, it would prohibit misrepresentations by individuals who falsely claim to be authorized to practice immigration law. This narrowly crafted provision would establish targeted criminal penalties for the flagrant abuse of immigrants seeking relief. It would hold accountable those who take advantage of some of the least sophisticated consumers. This measure provides a much-needed tool for prosecutors to prevent this type of fraud and abuse. And finally, the bill would criminalize threats and retaliatory acts associated with the provision of fraudulent immigration services. These provisions of the bill are particularly important. Notario fraud schemes are very rarely reported because so many immigrants are afraid of retaliation. By some estimates, only 1 in every 100 cases is ever reported to the authorities. Failure to report these crimes, along with limited prosecutions, allows notarios to continue their scams. With this bill, greater focus and emphasis will be placed on notario scams by providing additional authority and resources to prosecute these crimes, including through the creation of no fewer than 15 special United States attorney positions to prosecute notario fraud crimes. I thank Representative Escobar for her leadership in introducing this vital legislation, and I ask all my colleagues to join me in supporting this bill today. I now recognize the ranking member of, I now recognize Mr. Biggs for his opening statement.
I thank the chairman. H.R. 4435 is the majority's effort to deal with what they see as a serious situation, and I also think it's a serious situation. It seems obvious to me that it is. Within my district, we have notarios that are practicing. I don't know the extent of whether there's fraud or whether they're legitimate, but I do see their storefront offices going through my district. Chapter 47 of Title 18 of the U.S. Code deals with fraud and false statements, though. And in that chapter, there are currently 40 sections. This bill would make it 41. And this is what I would refer to as overcriminalization. Certainly, there are other state or federal laws that could deal with notario fraud. We should be looking, in my opinion, at shrinking Title 18, shrinking the criminalization, not growing it. This bill also directs the Attorney General to establish at least 15 special United States attorneys to prosecute these crimes. Now think about it. When you look at in the sections of this bill, and you look at the fraud section or the misrepresentation section, these are misdemeanors. And you're going to assign 15 U.S. attorneys to investigate misdemeanors. I question whether that's a wise use of our limited resources. I wish that the supporters of this bill shared my view, and I'm sure I'll have more to say as we go along, and I'll yield back, Mr. Chairman. Thank you.
The gentleman yields back. I now recognize the ranking member of the Crime Subcommittee. I'm sorry, I now recognize the chair of the Subcommittee on Crime, Terrorism, and Homeland Security, the gentlelady from Texas, Ms. Jackson Lee, for her opening statement.
Mr. Chairman, thank you very much. And I am proud to be an original co-sponsor of H.R. 4435, the Fight Notario Fraud Act, and thank the chairman for addressing this important issue, and of course, my colleague and fellow Texan, Ms. Escobar, for her leadership on this issue. The bill makes necessary changes to federal law to ensure the appropriate prosecutorial tools are in place to target those who prey on immigrants, some of the most vulnerable members of our society. Notarial fraud refers to the practice of unlicensed immigration consultants offering immigration legal services, and they are plentiful. Their advertisements, their signs, their tweets, their cards are everywhere. Unfortunately, it has been an ongoing problem in my district and many districts around America. The gravity and scope of the notarial fraud problem in the state of Texas cannot be understated. According to one report, almost 100 businesses have been closed for offering legal services without the required authorization since 2002, just in my home state of Texas alone. But what happens is it provides or it leaves open the individuals who use these services to a desperate circumstance, that they're not in compliance, that they haven't done what they're supposed to do, that they're subject to deportation. It is absolutely tragic. One report from my district highlights the economic and legal harm of these bad actors. One of my fellow Houstonians discovered 18 years too late that the notario that she has contracted with had bilked her out of more than $15,000. This so-called notario also never notified her that her application for permanent legal resident status had been rejected years ago. Other immigrants have discovered that their applications were bungled, their ability to change their status ruined. Notarial fraud has destroyed the American dream for too many. These schemes also reduce community trust in the immigrant process, which in turn has the effect of chilling immigrants' participation in prosecution of notarial fraud. Notarial fraud perpetrators take advantage of their victims' lack of familiarity with our complex immigration laws and exploit the fear of some immigrants to report crimes to government authorities. This bill includes protections against retaliation for reporting instances of notarial fraud. This type of protection is necessary to encourage reporting of these types of illegal practices. There's also an important addition to the 117th version of this bill that I want to highlight for my colleagues. This Congress, the bill includes a provision focused on the linguistic competency of any federal prosecutor appointed to serve in any of the special U.S. attorney's positions established by this legislation. As a result, prosecutors should be more effective in the prosecution of cases involving non-English speaking victims and witnesses. Additionally, having prosecutors who speak the language of the victims is critical to promoting trust in the community. This is especially true in Texas. Houston Public Media has also reported that notarial fraud scams are also targeting Houston's Vietnamese-speaking community as well. The bill also requires that 15 federal prosecutors be designated to handle these cases. In doing so, the bill will also prioritize and promote affirmative steps to protect immigrants from notarial fraud. Communities like my hometown of Houston need immediate action and attention to stop notarial fraud and to hold notarial fraud scammers accountable. I venture to say the nation needs this legislation. Moreover, this committee must encourage practices like those in the Fight Notarial Fraud Act that meet the needs of victims. I thank my fellow Texan, Representative Veronica Escobar, again, for taking up this legislation and for her leadership on this issue. I also thank the chairman for, again, moving forward on this important issue. And I want to acknowledge an article that deals with the notarial fraud scammers target Houston's immigrant communities, and immigrant lawyers warn of notarial fraud. I ask unanimous consent to submit that into the record.
Without objection.
And I ask my colleagues again to support the underlying bill for this important issue. Thank you.
Lady yields back. Without objection, all other opening statements will be included in the record. Are there any amendments to H.R. 4435? For what purpose does Ms. Escobar seek recognition?
Thank you, Mr. Chairman. Move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, I am so proud to be able to continue the work from last Congress of my friend and former colleague Debbie Mukersel-Powell, who did some incredible work on this bill. I'm proud to continue the fight to protect some of the most vulnerable members of our society, and I'm so proud and grateful to my co-sponsors, Representatives Sheila Jackson Lee and Sylvia Garcia, my colleagues from Texas. The Fight Notario Fraud Act gives the Department of Justice the tools to go after perpetrators of notario fraud. This bill criminalizes providing fraudulent immigration services, misrepresentations by certain individuals claiming to be authorized to practice immigration law, threats or retaliation against victims of notario fraud, and directs the Attorney General of the United States to establish no less than 15 U.S. attorneys to investigate and prosecute reports of notario fraud. One of my colleagues mentioned concern about that particular aspect of the bill, and I would just like to emphasize that the impact that notario fraud has on the lives of some of the most vulnerable among us is devastating. People's ability to access the legal immigration system is at stake. People's livelihoods are at stake. People's families are at stake. I cannot emphasize enough the devastation that comes with the fraud related to notario fraud. And in fact, this is fraud that is perpetrated all over the country. I have heard from colleagues who represent different states all over America who say that this is a badly needed piece of legislation. And so this would bring relief to communities all across America. Grifters, many of whom are certified notaries public in the US, misrepresent their credentials to potential victims and offer immigration services they are not qualified to handle. We all know how complicated the US immigration system is. We all know that there are fewer legal avenues today, fewer than ever before, and we all know how complex it is already. And so when these grifters offer services to vulnerable immigrants and rob them of their opportunity, that should be alarming to all of us. In addition to taking thousands of dollars from their victims, scammers often commit filing mistakes, give incorrect legal advice, and many have even lost or stolen important documents vital to their victims' immigration cases. Sometimes the damage caused by scammers is severe and irreversible and can cost victims their immigration case and their status in the United States. Fear of retaliation from scammers and fear of deportation by the US government means that victims of notario fraud rarely come forward to report the crime. Notario fraud is so underreported that it is difficult to find accurate statistics, though some estimates find that only about 1 in every 100 instances of fraud is ever reported. This committee voted the Fight Notario Fraud Act in a bipartisan manner out of this committee last Congress and must do so again. I urge my colleagues to support this bill, and I thank everyone who helped make it better. Mr. Chairman, I yield back.
The gentlelady yields back. There are votes on the floor. We're going to recess the committee until immediately after the votes, so please come back immediately after the votes. The committee stands in recess. The markup will come to order. We will now resume consideration of H.R. 4435. Who seeks recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you for bringing this bill forward. Today, we take bold steps to address recidivism and sentencing disparities, provide equal access to Veterans Court treatment programs for racial and ethnic minorities and women, as well as address individuals who claim to practice immigration law and misrepresent themselves. I'm especially proud to co-lead the Fight Notario Fraud Act of 2021, which would hold public notaries accountable who abuse their power. Some of these bad actors take advantage of vulnerable communities with language barriers, or of those who cannot read or fully understand the American legal system. Many Spanish-speaking immigrants, for example, turn to notaries because in their home countries, a notario público refers to a lawyer. So H.R. 4435 criminalizes notario fraud schemes, ensuring that no one can take advantage of the literal-sounding translation of notario público. Significantly, some scammers have fraudulently used the notary public title to market themselves as authorized to provide legal advice and services, especially in immigration law. When I was a legal aid lawyer, I remember seeing firsthand many of the deceitful practices at the expense of indigent people due to their illiteracy or a language barrier. Sadly, that was wrong then, and it is still wrong today. As a member of Congress, we've gotten many of these similar complaints, so the practice still continues. We have a responsibility to protect the well-being and livelihoods of the most vulnerable among us, including immigrant families across our country. Certainly, courts have recognized the widespread prevalence of notario fraud, and the negative impact on immigrants and their families is clear. I want to thank my comadre, Congresswoman Veronica Escobar of El Paso, and Congresswoman Sheila Jackson Lee, my colleague from Houston, for their leadership on this issue, and I thank them for their continued work that started with our other comadre, Debbie Mercosal-Powell of Florida, formerly with us on this committee. I urge my colleagues to support this important legislation. Let's put an end to these fraudulent schemes. And Mr. Chairman, I agree with Mr. Biggs. 15 U.S. attorneys is something we should rethink. Frankly, that's just enough for Texas. What are we do about the rest of the states? We should make sure that if we're going to ask for these cases to be prosecuted, that we have enough staff to handle the number of complaints that I know we get in Texas, that he gets in Arizona, that they get in California, New York, Florida, and I could go on and on. Mr. Chairman, this is an important piece of legislation. I urge all my colleagues to support it. With that, I yield back the balance of my time, and I thank you so much for your leadership on this issue.
Gentlelady yields back. For what purpose does Mr. Stetton seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. And I am proud to support H.R. 4435, the Fight Notario Fraud Act of 2021. I urge my colleagues to do the same. This bill addresses an issue that affects way too many people in my home state of Arizona. Fraudsters, often without any credentials, pose as legal professionals, offering immigration services to unsuspecting targets. They prey on vulnerable immigrant communities, of whom many do not speak English as a first language. The notario provides advice and counsel as if they are an attorney, but in fact they are untrained, unlicensed, and too often malicious. The risk posed by these scams is obvious. Mistakes in immigration proceedings and paperwork carry heavy penalties, and too often the victim of these swindles is left with little or no recourse and faces threat of retaliation. The Fight Notario Fraud Act of 2021 would fix this by criminalizing these fraudulent activities and establishing at least 15 special U.S. attorneys to prosecute the bad actors. And I also want to offer my thanks to Representative Escobar, Jackson Lee, and Garcia for their ongoing leadership on this issue. And I ask my colleagues to join me in supporting this important bill. I yield back.
Gentleman yields back. For what purpose does Ms. Ross seek recognition?
Mr. Chairman, Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. The Fight Notario Fraud Act of 2021, led by my colleague Representative Escobar, addresses real harms incurred to vulnerable immigrant communities that fall prey to notario fraud. Spanish-speaking immigrants in particular often face confusion about the role and power of notaries and can be led to believe that notaries are legally authorized to provide legal services. I have seen this in my state. These predatory practices have immense and often irreversible consequences on immigrant communities. Fraudulent notary practices can lead to the missing of key deadlines and the filing of incorrect, incomplete, and false claims with the government, leaving individuals with not only missed opportunities to obtain legal residency, but the possibility of facing criminal liability and deportation. I represent a district with a large immigrant population that's benefited from rigorous enforcement of state laws that prohibit notary fraud. However, not all states have these laws. I'd like to highlight the leadership of North Carolina's Secretary of State, Elaine Marshall, who has led the charge in preventing notario fraud by increasing the capability of the state to investigate misconduct, and has worked with the state bar to provide continuing legal education for attorneys that help identify notorio misconduct. She's also improved methodologies to positively identify document signers. But again, all states do not have these protections, and that is why we need this important piece of legislation. I urge my colleagues to support the bill, and I yield back.
The gentlelady yields back. For what purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, for putting this legislation for our consideration today, and thank you to my friend, Representative Escobar, for introducing this important bill. As co-chair of the Legal Aid Caucus and someone who's worked for decades to expand access to legal services for those in need, I've seen how important access to quality legal counsel is. This is especially true in immigration matters, where our complicated laws and broken bureaucracy are difficult to navigate, even with legal counsel. But I've heard too many heartbreaking stories from vulnerable immigrants who were defrauded by notarios, posing as legitimate immigration experts. These notarios take advantage of the complexity of our immigration system and the fears of immigrants seeking to navigate it in the hopes of making a better life in our country. And the impact of these fraudulent notarios is devastating. Not only do they extort hundreds of thousands of dollars from families who count on them for sound legal advice, but they often, through fraud or incompetence, irreparably damage legitimate opportunities for our immigrants to gain visas, green cards, and other legal immigration status. That's why I'm so proud to support this legislation, which would criminalize unlawful notarial schemes, as well as any threats and retaliation associated with those schemes. Additionally, I'm pleased that this legislation would allocate DOJ resources to ensure that notarial fraud is rooted out and stopped before it can ruin the lives of immigrants looking for legal counsel. Ensuring access to quality, affordable legal aid should be a priority for our committee and this Congress. And part of that effort lies in rooting out bad actors who aim to take advantage of vulnerable individuals looking for legal assistance. I encourage my colleagues to support the Fight Notarial Fraud Act, which would make meaningful change for immigrants across our country. Thank you again to my colleagues for your leadership and your focus on this important issue. I yield back.
The gentlelady yields back. For what purpose does Mr. Biggs seek recognition?
I have an amendment at the desk.
Clerk will report the amendment. Point of order is reserved. The clerk will report the amendment.
Amendment to H.R. 4435, offered by Mr. Biggs of Arizona. Add at the end of the bill the following: Section 3, inadmissibility and deportality.
The amendment will be considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Well, Mr. Chairman, my amendment is quite simple. I mean, we've heard a lot of passion about the gravity of notario fraud, and I'm not minimizing it at all. I think that it probably does, and it is such a problem, quite frankly, because it is being this type of fraud and this kind of action is being used to prey on aliens who are living in the United States. And those who are holding themselves out to be immigration specialists, they take the money of unsuspecting aliens in that way. They're not the kind of people, if they are foreign nationals, that we really want in the United States. They have violated a very serious law. They've impersonated lawyers. They've, and you guys on the other side have really cataloged all the things that can happen and the impact on lives. I was kind of surprised that you left it a misdemeanor, though. So what my amendment does is it ensures that a foreign national who commits notario fraud, as defined by this bill, is both inadmissible to and deportable from the United States. See, a misdemeanor conviction is not enough for the Biden administration to make an alien a priority for removal. So the least we can do, in my opinion, is to speak with a strong, unified voice that people who commit these types of crimes, who are here and they're foreign nationals, they should be removed from the country. I hope that all of my colleagues will work with me to convince the Biden administration that aliens who commit notario fraud and all other aliens convicted of crimes should be removed from the United States of America. Now, when I look at this too, what I find interesting is I think there's an additional flaw in the bill. I'm not going to offer an amendment. I mean, I don't know that it necessarily is appropriate for me to offer that amendment, but I wish you would consider this. When you get to, on the 5th page, line 19, linguistic competence, I understand that you want linguistic competence, but I want to give you some context. You're going to have 15 special U.S. attorneys, and their linguistic capability, their multilingual capability will be considered. The way this is structured here, I hope they speak a lot of languages, because, for instance, in the Yuma sector, just about 6-8 weeks ago when I was down there, the #1 country from which people were being apprehended was Brazil. And I talked to the head of the station. I said, well, how are you doing? Because that's a Portuguese-speaking nation. He says, we don't have interpreters. We don't have translators. That's a problem. What was #2? Russians. Had trouble getting Russians speakers to translate. Romanians, the big groups the two big groups I saw when I was down there, Romanians. That's a problem. So when you have this kind of clause here, you might have an unintended consequence that you can't fulfill the qualification requirement for your U.S. Attorney General, Assistant U.S. Attorney General. I raised that because I don't know that that's intentional. I suspect it's not, but I think it possibly could be a problem. I don't think you're going to have a problem with more common languages like Spanish or even French, but there's also Mandarin and Cantonese speakers. There are Farsi speakers that have come across, and I would assume that some of them are also victimized by notario fraud. The reason I say that is because in my district you can go and you can find many notarios in storefronts, shopping centers, and so if you're coming across, regardless of what country of origin, you might end up there instead of at a lawyer. Now, I would just raise one other issue that does concern me, and I raised this, and it's not meant. I don't mean to be offering this with humor, but I'm trying to figure out why the state bars, and I belong to 3 different state bars. I would like to know why they're not enforcing provisions against non-attorneys practicing law. I wish they would, and I think that's a problem here, and I think you're trying to correct that, but I think it might be better served in that way. So I urge everyone to consider my amendment. I hope it gets adopted, and with that, Mr. Chairman, I'll yield back.
The gentleman yields back. The gentleman yields back. Does the gentlelady insist on her point of order?
I do insist on the point of order, Mr. Chairman. The amendment purports to amend Section 8 of the U.S. Code, whereas the bill is entirely about Title 18 of the U.S. Code. Therefore, it's beyond the scope of the bill, and it is not germane.
Mr. Chairman.
Gentlelady, gentleman will be heard on the point of order.
Yes, I'd like to be heard if I might.
Gentleman is recognized.
Thank you, Mr. Chairman. I recognize that we're talking in two different sections, but of the U.S. Code. But I think what's important to understand here is, if you go to page 2 and you begin looking at under section 2 and you start going through this, everything in here, and particularly on page 3, on lines 5 through 17, everything there is geared and discusses immigration status. Is the notario fraud impacting immigration status? Is there something about perceived immigration status or attempts to secure immigration status that impacts the person's or results in the removal of that person from the United States or leads to the loss of immigration status? All of those things there go hand in hand with the immigration laws that my amendment is dealing with. It is extremely germane. It goes hand in glove with this. I'm kind of surprised that this was raised, but in reality, I think, Mr. Chairman, if you look even in lines 12 through 15, or 16, I mean, in clause C, again, talking about person applying for an immigration benefit or to lose the opportunity to apply for immigration benefit. We are talking about that through and through, and it seems to me that this is dependent upon this bill, and I urge that it be ruled germane, Mr. Chairman.
The chair is prepared to rule. Clause 7 of House Rule 16 prohibits amendments that are in a subject matter different than the proposal that is under consideration. The subject of the amendment, the subject of the bill we are currently considering is fraud and false statements regarding immigration law. The gentleman's amendment proposes to amend immigration laws that are not addressed in this bill, which is a subject different from what we are considering in this bill. The amendment, therefore, is not germane and violates Clause 7 of Rule 16.
Would appeal the ruling of the chair.
I move to table.
Motion to table is made. The motion to table is not debatable. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee.
In the non-definitive sense, no?
Mr. Cohen.
I'm going to put you on hold for 1 second. Aye.
Mr. Cohen. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass. Ms. Bass.
You're muted.
Aye. Aye.
Ms. Bass votes aye. Mr. Jeffries.
Aye.
Mr. Jeffries votes aye.
Sorry.
Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin. Mr. Raskin.
Mr. Raskin, you're muted.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Demmings. Ms. Demmings votes aye. Mr. Correa.
Aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones. Ms. Ross. Ms. Bush. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat. Mr. Gomert. Mr. Issa. Mr. Buck. Mr. Gates.
No.
Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Stube?
No.
Mr. Stube votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Owens?
Owens, no.
Mr. Owens votes no.
Mr. Chairman, how am I recorded?
Mr. Isa, you are not recorded.
I vote no.
Mr. Isa votes no.
How am I recorded?
Ms. Jackson Lee, you are not recorded.
Yes. Yes.
Ms. Jackson Lee votes yes.
Mr. Swalwell?
Aye.
Mr. Swalwell votes aye.
Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Yes. How am I recorded?
Mr. Shabbat?
Mr. Shabbat, you are not
how am I
recorded.
recorded? You should have saw. I don't think it hears me.
You are not recorded.
Okay. No.
Mr. Shabbat votes no.
Thank you.
The clerk will still report.
That was pretty impressive, wasn't
Mr. Chairman, there are 20 ayes and 14 noes.
Mr. Biggs' motion to appeal the chair's ruling in his amendment is laid on the table. Who seeks recognition? For what purpose does Mr. Correa seek recognition?
Mr. Chairman, I have an amendment at the table.
The clerk will report the amendment.
Amendment to H.R. 4435, offered by Mr. Correa of California. Page 6, after line 3, insert the following and
The amendment will be
redesignate.
considered as read. The gentleman will explain his amendment.
Thank you, Mr. Chairman, for holding this most important markup today, and I want to thank Ms. Escobar, the sponsor of this bill, for reintroducing it once again. This bill holds criminals accountable for their crimes for misrepresenting their qualifications to practice immigration law. In my district, this is a minor crime that happens every day that adds up to millions and millions of dollars of damage. A few years ago, the Guadalupana law firm made the local headlines before a local district attorney shut them down. This firm was made up of crooked attorneys, bad notaries who took millions of dollars from hardworking immigrants. And by the time authorities shut them down, they had fled the country. And the worst of it is that these attorneys and advisors recommended that their victims sign documents that were not true, resulting in many of these victims permanently being disbarred from legalization, or barred, I should say, from legalization. I support this Notario Fraud Act, but there is so much more that needs to be done. Let's not forget the real damage is to the victims. They should have at least the opportunity to seek monetary restitution. That's why my amendment requires that practicing immigrant attorneys and accredited immigration representatives have adequate errors and omissions insurance so that victims may be compensated at least partly for their harm. And with that, I support the bill and I withdraw my amendment.
The amendment is withdrawn. Are there any other amendments are there any other amendments?
Mr. Chair. Reserve a right to object.
For what purpose does Mr. Fitzgerald, seek recognition.
Mr. Chair, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to HR
Point of order is reserved.
to 4435, offered by Mr. Fitzgerald of Wisconsin, page 3, after line 19.
Without objection, the amendment is considered as read. The gentleman will explain his amendment.
Thank you, Mr. Chair. I guess I would start with saying, once again, we find ourselves kind of in a position of the bill is got a laudable goal, and obviously with what we're hearing and what's been demonstrated today is that this is needed. But I think I do have an amendment before the committee that would once again tighten things up, make things a little bit more succinct, and actually I think improve on the statutes. I guess I would also say I'm disappointed that Mr. Correa had withdrawn his amendment, because actually what I'm seeing is that amendment kind of speaks to what we are recognizing as one of the issues. And that is, once again, the cartels, and let me further describe, by definition, they're more transnational criminal organizations. Just, you know, I know that there's different terms that are used sometimes for the cartels, but I wanted to just reiterate that, you know, this is a global issue, not just something happening within the borders, certainly of the United States, but also our bordering countries. So what this amendment would do is, and DOJ has been asking for some of this stuff. They have been trying to root out immigration law fraud and prosecute notarial fraud under mail and wire fraud. That's been going on. It's been going on for a long time. So, because obviously we know fraud's never acceptable, and it's an unauthorized practice. I don't know if you want to call it a shell game, and the way it's been described numerous times is misrepresentation of legal services. So this amendment would allow judges to increase sentencing for any violation of this act when the individual involved is, guess what? Related to the cartels, related to these transnational criminal organizations. And you would say, well, how would you determine that? Well, the way you would determine it is by the case or by trying to prosecute. You know, that's how this would emerge. That's where this would come from, is in that prosecution. Because that would reveal the connection. Because otherwise, what we are led to believe, based on what we're seeing today, is that these are all just individuals operating on their own. Come on. That's not true. We know that's not true. So I think this amendment goes a long way to, once again, improving the bill, improving the efforts of the author. I applaud Representative Escobar in what's going on here. But again, I think this amendment addresses something that clearly is happening and would make this bill much better. I would yield back.
The gentleman yields back. For what purpose does the gentlelady from California seek recognition?
I move to strike the last word.
Oh, do you insist on your point of order?
I had the point of order. I do not insist on my point of order.
Point of order is withdrawn.
It is withdrawn.
Gentlelady is recognized.
I'm pretty confident that every single member of this committee opposes the drug cartels. I mean, that's a given. And most of them are transnational organized crime. But I don't know really what else is transnational organized crime. To be honest, although I have watched these predators for many years, the notorios, I've never once, even when there have been local prosecutions, there's never been an instance where they were connected with the cartels. So I think this is worthy of further investigation, but I think the drafting of this is loose enough that I don't know that we would know what we would be voting to approve. So I couldn't support this today, but I do, and I don't think there's really any nexus, honestly, between the notorios and the cartels, although if there is, certainly we would want to do something about that. But whether or not there's a connection between the notorios and the cartels are a threat. They're a threat to our country, and they're a threat to individuals who run into them, whether those individuals are documented or undocumented. They're a threat to our law enforcement officers. They're bad dudes, and we're against them.
Would the gentlelady yield for a question?
I would be happy to yield.
I thank the gentlelady, and I guess the question that occurs to me as I hear your argument in response to this amendment is, what harm does it do? It would apply an enhanced penalty if someone who's engaging in this conduct that the bill seeks to strike at also is a conspirator with one of the cartels.
Reclaiming my time, transnational organized crime is not defined, and that's the concern. When we pass a law providing for imprisonment of 4 years, I think we ought to know specifically what the terms mean, and we do not know what the terms mean in this amendment.
Would the
gentlelady yield?
Let me just finish, and I'd be happy to yield. That doesn't mean that we couldn't find out. We could. We could have a hearing. We could do some research, but I don't think we know at this moment what that term means, and I'd happy to yield to the gentlelady who's done so much good work on this bill, the gentlelady from Texas.
Thank you so much, Ms. Lofgren, Representative Lofgren. To my colleagues, I think you know I represent El Paso, Texas, on the southern border, a border community. Before I was in Congress, I served in local government, and so I've been fortunate to be a public servant for a long time for my border community. I have, even as a local elected official, I received countless complaints from community members about notario fraud. I have never once heard that they are linked in any way, in the way that is identified in this amendment, not once. And I have been as close to the community as it gets. In recrafting this bill and speaking with colleagues from across the country, I have never once heard that this is an issue. I would be very interested in any examples that you all might have come across, because if there is even one example, I'd love to explore it, talk about it, and as Ms. Lofgren mentioned, perhaps even have a hearing about it. And I will tell you, I am someone who believes that the cartels are evil, and the way that they prey on some of the most vulnerable human beings is detestable and horrific. And so I absolutely stand with anyone who wants to legislate to create better safety for the most vulnerable against the evil that is the cartel. But I think it's so important to make sure that when we legislate to solve a problem that exists, and we don't create overreach for something that doesn't exist. And so I would love to hear any examples that might exist, but after years in public service, I have not. And thank you so much, Ms. Lofgren, for yielding. I appreciate the time.
I thank the gentlelady for yielding back. I would just note that over the years, I've run across cases where just horrendous situations have occurred because of this fraud. And it's important that this bill, which I think has a match in the Senate, pass and pass along the lines that can pass in the United States Senate, because real harm is being done to innocent people who are trying to comply with the law. And with that, Mr. Chairman, my time has expired.
Gentlelady yields back. Who seeks recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you. And I wonder, it seems to me that this is, I have a hard time seeing what's difficult about this. I do understand the comment of the gentlelady from California, I guess, in a technical way, that there's no definition in the amendment of a transnational organized crime. But then again, I doubt that's a very big obstacle. And I don't see what mischief could occur because it's not a term that is likely to be thought of as ambiguous. Organized crime's pretty clear. Transnational organized crime's pretty clear. And so the possibilities or the problem, it seems to me, would exist if a court were to overinterpret it to include a bunch of stuff that wouldn't be included.
Mr. Bishop, will you yield?
I'd be delighted to yield to the gentleman.
I just want to associate myself with the remarks of the gentlelady from California. This is a criminal statute, and so there are significant problems if definitions are not provided, because you have to provide notice to a defendant or an accused of what the circumstances are that led to the charges that have been leveled against him. I was a practicing criminal defense lawyer for many, many years. You can't leave it up to courts to decide what those terms mean, because that doesn't provide sufficient notice to an accused. It raises serious due process questions.
Reclaiming my time, and I'd be delighted to perhaps extend more time but just to engage in something in the nature of a colloquy if we could. I would submit that we were just in a very long markup over some bills that had great potential impact, that had some terms that were extraordinarily broad and ambiguous and not defined, like critical trading partner, if that one rings a bell. And so invariably, courts have to interpret words that Congress has not defined with great precision, but I would contrast this situation with that one and invite the gentleman from Rhode Island to comment on that.
Yeah, of course. Well, there's obviously a very significant difference between a criminal statute that imposes penalties of imprisonment and requires due process considerations that don't exist in the civil context. So they're completely different circumstances.
Reclaiming my time, is the gentleman's proposition that the language transnational organized crime would be so ambiguous as to raise a due process objection?
The absence of a definition, it's not a question of whether it's ambiguous to you, it's to whether or not there is a definition that provides an accused with a clear understanding of the prohibited conduct. That's just not contained in this amendment. And by the way, critical trading partner had a definition on our bill. But there's a reason you have to provide an accused with the actual definition of the conduct that you are criminalizing. So the person is on notice that if you engage in this, you can lose your freedom and go to prison. You don't leave it up to a court to later on decide whether it met that definition. That would turn the due process protections on their head.
Would the gentleman yield?
Or up to me, it's not my
Bishop,
time.
Reclaiming my time. Well, let me then yield for a moment and give me some time if you go back to Mr. Biggs.
Yeah, I'm just looking at the definition in USC Title 10, Section 284.16, which defines transnational organized crime. And it seems to me that that's in the statute, it's defined, and so it would obviate the argument that it's indefinable, because it's in statute already, that definition, 10 USC Section 284.16.
I thank the gentleman, and perhaps to facilitate or solve the problem, I seek to be recognized to offer a second-degree amendment. Mr. Chairman.
Seeking to be recognized to offer a second-degree amendment.
I seek to be recognized to offer a second-degree amendment.
Gentleman is recognized.
And the amendment is at the desk.
Clerk will report the amendment.
Yeah.
Reserve a point of order.
Point of order is reserved.
Amendment.
Point of parliamentary inquiry, Mr. Chairman. Who controls the time right now?
I've just sought to be recognized for a second-degree amendment and was so recognized.
Okay.
Amendment to H.R. 4435, offered by Mr. Bishop. Page 3.
Without objection, the amendment is considered as read. The gentleman will explain his amendment.
I thank the chairman, and I assume I get a new 5 minutes.
Yes.
Right, thank you. Thank you, Mr. Chairman. So this second-degree amendment will interpose the language following the term transnational organized crime with a definition, which is an offense whose inception, perpetration, or direct or indirect effects involve more than one country. And I think that solves the problem to which Mr. Cicilline spoke. And again, it seems to make great sense in terms of it certainly ought to absolve any concerns whatsoever about Mr. Fitzgerald's amendment, because all his amendment does, for goodness sake, is say if someone who's engaged in this notario fraud that the bill strikes at is also engaged in this transnational organized crime that we all know, and Ms. Lofgren made the comment, everybody's against it, and frankly, the enhancement's not that significant. There are crimes, penalties as long as 3 years against these folks for notario fraud in the bill, if it involves, I think, a matter in more than $10,000. And in this case, it would then, it just extends it to 4 years if the person's participating with the cartel. How easy should that be?
Would the gentleman yield?
So I'd be, I understood someone wanted me to yield back here, is that correct or no? No, okay. Yes, I'd be delighted to yield to the bill sponsor.
Could you give me an example of when this has happened?
I couldn't speak, frankly, I don't have the knowledge of when a notario fraud has happened, but I've heard from members of the panel across the board that it's happening a lot, that these people are bad people. I do know that the cartels are very involved, as I'm sure you do, that by virtue of the open border that the Biden administration has undertaken, the cartels are bringing people across the Rio Grande, getting paid $6,000
Just to be clear, you don't have an example of this ever happening.
But I don't have an
Correct?
example.
Okay.
I'm fixing the definition, and perhaps Mr. Fitzgerald would want to speak to it, but I do not have an example because, again, I don't have an example of notario fraud.
Would the gentleman yield?
I would yield to the chairman.
I thank the gentleman. Let me just say that the original amendment, because it is so broad in a way without the definition, in a criminal offense, as said by Mrs. Cicilline, is insupportable. And the secondary amendment is so vague that it doesn't solve the problem. So I just want to say that I have to oppose the secondary amendment, and I have to oppose the amendment. And I yield back. I have to yield.
It's his time, so.
Mr. Chairman, reclaiming my time.
Yes.
I understand that there's a source of that definition. It's the definition of transnational organized crime according to the United Nations, which seems like, boy, I would think that would work for you tremendously well. And I submit that it really does clean this up very much, and I hope that therefore the majority would be delighted. The majority certainly opposing transnational organized crime, certainly be opposed to the cartels, as the gentlewoman from California indicated everyone is. Let's dispense with this quickly. And
Mr. Bishop, will you yield for a question?
I do yield to the gentleman from Rhode Island.
I don't think anyone questions your intention here, but I guess my question is this. I think you're conflating two problems. I think we all agree transnational crime and organized crime is a serious problem. Maybe the notorious fraud that is the subject of the bill may be less familiar to you, but these are crimes which are committed against the immigrant community relative to accessing legal services or immigration services, where people are essentially defrauded of money in their effort to either stay in this country or go through some immigration process. That's not a fertile area for organized crime. This is victims of defrauding individuals who are trying to access legal services. So let me just finish real quickly.
Reclaiming my time. I get your point, Mr. Cicilline, but and to respectfully, the response to that is, well, then there should be no harm. If a notario is also a member of a cartel, then they get an enhanced sentence. Who can be opposed to that? It's really easy. So even if it's not likely that these reprehensible notarios we're hearing so much about could also be a member of the Mexican cartel, I mean, I don't know why that's so implausible, but then again, I'm from North Carolina. But I submit that we've solved the problem of the definition. That cleans up the due process problem. I appreciate your contribution on that point. We've cleaned this up. We could really get this dispensed with very quickly. And with that, I yield back.
Gentleman yields back.
Madam
Does anyone else wish to be heard? Ms. Jackson Lee is recognized.
Thank you so very much, Mr. Bishop. As I strike the last word, and also I withdraw my point of order, let me just say that your amendment is worthy of further discussion But I do believe my colleague and my colleagues, plural, are seeing these every day in their districts, Congressman Escobar, Congressman Garcia, and myself. We're seeing the real life, daily, in the United States, domestic-based individuals who are seeking, and let me just read very quickly. Immigrants hire these persons to file taxes, work on immigration papers, and handle other legal matters. Scammers then steal their tax return money, overcharge clients, and botch paperwork. These are some of the things. They're also, their culture, they're coming from a country where a notario is someone that is highly esteemed, is respected in the community, has all these credentials to practice law, though they're not. So when they come across this person in the United States, of course, they assume this is a person that could help with my immigration case. And I think I asked to submit the notarial fraud scammers into the record as unanimous consent article and immigration lawyers. My point is that your idea is worthy, again, as I indicated to Mr. Fitzgerald, of a more intense review, a transnational review. But I do think you have some Achilles heels. The definition, even though you tried to amend it, and the expanse of what you do in this as opposed to what the bill is. The bill is narrowly framed to deal with these scammers that attack our constituents every day. And so I would make the argument that we can do this another time. Hate to say that, we've said that before, and that we can address the complexity of transnational organizations dealing with immigration crime or dealing with crime. With that, I would have to oppose the amendment and the underlying amendment, and also, as I conclude, hoping that we will pass Ms. Escobar's bill. I ask that we support the underlying bill. I think it is a vital change to, in essence, really saving lives, because what happens is these people find out what has happened to them, the fraud, 15 years later, and they are in the mix of the immigration process to be deported, their children separated from them. It is a mess. This bill is long overdue and it is needed, and I think we should move quickly. As I say that, let me thank all of my colleagues for voting on bills out of the Crime Subcommittee in a bipartisan manner. Maybe you'll do that in this bill. And I want to thank the Crime Subcommittee staff for doing an excellent job for getting these bills out. Again, I ask that you support the Escobar bill, H.R. 4435, and that we do it in a bipartisan manner because it is needed. With that, Madam Chair, I yield back.
Gentlelady yields back. Does anyone else wish to be recognized? Mr. Tiffany is recognized to strike the last word.
Yeah, I move to strike the last word. Thank you, Madam Chair. So I think part of the reason that we want to include this amendment, we may not get another opportunity. And it appears to me that we have, as the gentlelady from Texas just said, this is a worthy bill. And, but this is a great opportunity, a golden opportunity, to be able to make sure that we deal with something that's very serious. I mean, we just heard from the gentleman from California. He was talking about, he broke up a ring, or they broke up a ring in, what was it, the LA area or something like that? I'm assuming that's where they're at. And they said they escaped across the border. You don't think that they were colluding? That sounds to me like that could be a transnational organization that was doing that. So, so I think that this is a great opportunity to be able to deal with an example that just came to us, and making sure to close a loophole and give us greater ability to be able to make this law even more effective and be able to get at people that are doing something that is really wrong to fellow human beings. And so I think the gentleman from Wisconsin, Representative Fitzgerald, really came forward with a good amendment here. And us being able to close this loophole with the transnationals and include them in the bill to make this bill really work to deal with a terrible situation that happens to people, I think this is a terrific opportunity. And as the gentlelady from Texas was saying, we should move quickly on this. We can dispense with the whole thing really quickly here by voting for this. And I urge everybody to vote yes to Mr. Fitzgerald's amendment And let's put on the second amendment also, the secondary amendment. And I think we'll have had a good day in regards to this bill. I yield back.
Gentleman yields back. I'd like to ask unanimous consent that we add an E to the second to the last word. I'm sure that was what Mr. Fitzgerald intended, more than one country, not more than on country. And without objection, that is done. Who else wishes? Mr. Johnson of Georgia is recognized.
Thank you, Madam Speaker. I move to strike the last word, and I rise in opposition to the amendment. And while I am sympathetic with the goals of this legislation, which seeks to get at notarial fraud, I have not been convinced that we need to make a federal case out of it. In the state of Georgia, such misconduct would constitute an everyday theft by deception or some other kind of fraud that is recognized under state law. And I assume that most states would have statutes in place that would get at the misconduct that this legislation seeks to get at. And with there being very slight evidence of any transnational activities with respect to garden variety notarial fraud, then it means that there's generally no organized conspiracy. It's just individuals set up on a street corner in a shop that advertise, and then they get a victim in there and they don't do the work that they promised to do, or they do it such that it is not effective, or sometimes they just skip off with the money and do absolutely nothing. But those are like garden variety theft cases. And so when we insert in the federal statutes a specific provision on notarial fraud, which primarily takes place in Latino communities across the United States, then we're opening up federal agents and federal prosecution focused on Latino areas and focused on Latinos. And I'm just, I'm not convinced that we need to go this far to get at this issue. I'm thinking it's more of a state issue, but I'm still open-minded, and I'm looking forward to hearing, continuing to listen to the debate as we move forward on this markup. And with that, I yield back.
Gentleman yields back. Who else seeks recognition? Mr. Raskin is recognized.
Thank you, Madam Chair. Perhaps it's unnecessary to get too much more deeply into it, but I just want to point out that the so-called secondary or clarifying amendment just adds multiple new layers of confusion, ambiguity, and vagueness to it. If you look at the insertion on the amendment, it says any person who violates subsection A, B, or C when it participates or conspires to participate in transnational organized crime, then the insert is, which is an offense whose inception, perpetration, or direct or indirect effects involve more than, I think that's one country. So basically with this amendment, we've defined an entity, which is transnational organized crime, as an offense whose inception or perpetration or direct or indirect effects involve more than one country. What would it mean to say that, okay, you've got international organized crime, if it is a crime, or if it is an offense, or its indirect effects relate to more than one country? What are the indirect effects of a crime? You could say that's everything. So, I believe the underlying bill is excellent and addresses a serious problem based on real empirical research that is actually going to advance the public interest. All of this just seems to me to be like legislative graffiti. It's just scrawling a bunch of ideas on paper, and it doesn't advance a real public interest. So I thank the author of the bill and those who are struggling to add an amendment. But if you want to deal with the problem of transnational organized
Will the
crime,
gentleman yield?
yes, by all means.
So do I understand that the UN definition of transnational crime is, in your view, what was it? Legislative graffiti?
Well, certainly in this context it is. I don't know where it's coming from. I don't know if all the misspellings were part of the original, but I don't like the way the United Nations spells perpetration or the word one. So yeah, I guess I would stick to American law rather than use UN law. That's what we're doing here. It seems to me that this is an ill-advised road to go down here, and there's a well-developed body of law dealing with transnational organized crime. And if you've got some ideas on how
Will the gentleman yield?
Yes, by all means.
There's also a well-developed body of law on dealing with the unauthorized practice of law, isn't there?
Well, not with respect to notarios, because this is a criminal statute. I think what you're talking about is either bar discipline or else the unauthorized practice
under state law.
I don't know whether that's ever been used before in this context. Do you know whether it has been?
May I ask you, sir, do you know whether there is any other subject matter where the unauthorized practice of law is prosecutable under federal law as opposed to by state authorities under state law?
Well, that's the whole purpose of the legislation, is to deal with this problem.
So the answer is no. You're not, for example, in bankruptcy practice, in tax practice, in trademark practice, you're not aware, are you, sir, of any other area where the unauthorized practice of law, the law of that, has been federalized and criminalized?
Well, sure. Under mail fraud, for example, there are people who would pretend to be lawyers who are prosecuted under the mail fraud statute or the wire fraud statute.
For the unauthorized practice of law?
Fraud.
If they pretend to be a lawyer and they defraud people out of their money, sure. Yeah, I can find you a lot of cases like that. In any event,
Madam Chairman.
Yes.
Mr. Raskin's time has not yet expired.
Okay. So Madam Chair, this is just to say that what we've got is a very worthy underlying legislative vehicle, and the amendment strikes me, whether it comes from the United Nations or somewhere else, it doesn't fit here. And I think it would just add a lot of chaos and confusion to the federal law. I yield back.
The gentleman yields back. Mr. Bishop?
Yes, I withdraw the second degree amendment.
Madam Chair, I seek recognition to offer second degree amendment.
I'm sorry. First, we have to get, by unanimous consent, we will withdraw the second degree amendment. And hearing none, that second degree amendment is withdrawn.
Thank you, Madam Chair. I seek recognition to offer a second degree amendment.
You are recognized for that purpose.
Thank you, Madam Chair. And
Clerk will report.
Amendment to H.R. 4435, offered by Mr. Biggs of Arizona, page 3.
By unanimous consent, the amendment will be considered as read, and the clerk will will hand out the amendment. And a point of order has been reserved by the gentlelady from Texas. You're recognized.
thank you, Madam Chair. And I appreciate the procedural safeguard to reserve a point of order, but this is basically, the first part of this amendment is exactly the same as the last part. The only thing that's different is, since there seems to be such a concern about the definition, what we've done here is we've actually defined it with the definition of transnational organized crime in Section 10 U.S.C. Section 284 I-6. So in that definition it says, and I want to read this so everybody understands what it says, so maybe it will clear it up and maybe ameliorate some of the concerns that I've heard. Number one, this is it. This is what it says. The term transnational organized crime means self-perpetuating associations of individuals who operate transnationally for the purpose of obtaining power, influence, monetary or commercial gains wholly or in part by illegal means, while protecting their activities through a pattern of corruption or violence or through a transnational organization structure and the exploitation of transnational commerce or communication mechanisms. And so you actually have the definition that is in the United States Code being inserted into this amendment being offered by Mr. Fitzgerald. Poor Mr. Fitzgerald, he thought he was offering a simple amendment that nobody could disagree with, and then we're trying to make it better.
The gentleman yield?
I'll yield to you, Mr. Bishop.
It would seem that whatever problem of illegal graffiti might have existed with my second-degree amendment has been 100% resolved with yours. Would you agree?
Mr. Bishop, I would wholly agree, and if Mr. Cicilline was here, he'd be calling you Mr. Biggs and me Mr. Bishop. But either way, I would agree. And we put this in here to make it very clear because I think maybe some of the questions were justified, although, you know, I used to do some international legal work, and I thought the UN had actually had some problems with its vernacular from time to time. But I think now you're going to be arguing against the U.S. Code because we've taken the language from the U.S. Code, trying to ameliorate some of the concerns of my colleagues across the way. I think that resolves it. I don't want to belabor the point, Madam Chair. We've had a lot of discussion today about this, and I don't think any of us thought we'd be having this kind of lengthy discussion. But I would say I hope we've ameliorated the concerns, and with that, I yield back to the
Gentleman yields back. I recognize myself in opposition to the second-degree amendment, and let me say why. I appreciate the effort that's been made to make this more certain and to address the ambiguities. But I think there are still some drafting issues that it's not clear that there needs to be conspiracy related to, and I've just pulled up, and I hope that Cornell law is right in terms of having the code online, but presumably they are. I would recommend that, you know, we take a step back and look at whether the issue of transnational crime and notorious are actually related at all. I don't believe there's any evidence that they are. If there is, I think we would have a bipartisan effort to do something about it. And I think this has gotten, of course, we're the Judiciary Committee. If we can complicate something, we will. But I think that at this point, we would be better off moving on to the bill itself, agreeing to talk together about whether the cartels are in fact at all connected with the abuses that we're finding in the notario business, and if so, make a pledge to work together on a bipartisan basis to deal with that. Does any other member wish to be heard on this second-degree amendment? Hearing none, the question is on the second-degree amendment. All in favor will say aye. All opposed will say no. In the opinion of the chair, the noes have it.
We have the ayes and noes. Yeses
The ayes and
noes.
nays
Yeses
have been
and nays.
requested. The clerk will call the roll.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
No.
Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no.
Thank you.
Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu?
No,
Mr. Liu?
Swalwell's a no. Swalwell's no.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Happy
Ms.
birthday.
Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach?
You're muted, Michelle.
Yes.
Ms. Fishbach votes yes. Ms. Sparts?
No. Nadler votes no.
Mr. Nadler votes no. Ms. Sparts?
Arts, yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Ms. Scanlon, you are not recorded. Ms. Scanlon votes no. Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
How is Ms. Jackson Lee recorded?
Ms. Jackson Lee, you are recorded as no.
Mr. Liu was attempting to be having technical difficulties. Has Mr. Liu voted?
Mr. Liu is recorded as no.
Okay. Does any other member?
How is Rep. McBath quoted?
Ms. McBath, you are not recorded.
McBath, no.
Ms. McBath votes no.
Does any other member wish to be recorded? If not, the clerk will report the vote.
Madam Chair, there are 15 ayes and 21 noes.
And the second-degree amendment is not agreed to. The question is now on the underlying Fitzgerald amendment. All those in favor will say aye. Opposed will say no.
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 In the
Yeas and days?
I was going to say, I believe that the noes have it, but the yeas and nays have been requested, And so the clerk will call the roll.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
Bass votes no.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Nadler votes no. Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts?
Sparts, yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz?
Bentz votes aye.
Mr. Bentz votes aye. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Are there additional members wishing to cast their vote?
Raskin votes no.
Mr. Raskin votes no.
Ms. Bush?
Bush votes no.
Ms. Bush votes no.
Are there further members wishing to cast their vote? If not, the clerk will report.
Mr. Chairman, there are 15 ayes and 20 noes.
The amendment is not agreed to. For what purpose does Mrs. Cicilline seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I'm delighted to report that we'll now return to the actual bill before us. And I want to thank my colleague, Congresswoman Escobar, for introducing this important piece of legislation. All too often, notaries painting themselves as legal service providers take advantage of immigrants seeking legal help. These fraudsters, often referring to themselves as notarios, take advantage of the fact that in many Latin American countries, a notario público can provide legal services. Here, however, that is not the case, as being a notary does not license you to practice immigration law. These fraudsters offer legal services to victims who believe they have hired a capable professional as they navigate our complex immigration system, but the providers are not actually qualified or certified to provide legal services at all. Victims often pay thousands of dollars and put their hopes and trust in these imposters, and they're left in the dust when they don't receive the help that is promised. These notarios often make mistakes in court filings and with other documents, which can have disastrous and sometimes irreversible harm on an immigrant status and on a particular case. There are also cases where the notarios skip town, often taking the victim's important legal and other documentation with them. A lucrative business for these notarios has grown out of deception and the suffering of thousands of victims. And I know firsthand, having received complaints about this when I was mayor and continue to receive complaints about these individuals as a member of Congress, this bill will help crack down on this abhorrent practice by making it illegal to provide fraudulent immigration services or misrepresent oneself as having a license to practice law. It also will require the Department of Justice to dedicate 15 attorneys to investigate and prosecute such fraudulent practices, and would create a public list of those convicted of providing immigration services unlawfully so others know to be aware of such bad actors. This legislation is extremely important and will help protect thousands of people from being taken advantage of, strengthening our communities and our legal system in the process. I want to end by again thanking Representative Escobar for reintroducing this important legislation, for her commitment to this issue, and urge my colleagues to support this effort to root out deceptive and predatory practices in our communities. And with that, Mr. Chairman, I yield back.
Gentleman yields back.
Mr. Chairman,
For what purpose does Mr. Bishop seek recognition?
to strike the last word.
Gentleman is recognized.
I thank the chairman. I will say that until I sat down at this hearing today, I had sort of missed the significance of this bill and not thought about the context, just hadn't had time. And then I looked at it, and as a practicing lawyer for a long time, I took note of the fact that as far as I know, and this is something I was getting at with Mr. Raskin, as far as I know, this would be the only subject matter of law in which one engaging in the unauthorized practice of law would be subject to federal prosecution and criminal penalties. And before I go further, I wonder if the bill sponsor would yield to a question on that point. Ms. Escobar, would you yield to a question?
Certainly.
Am I correct about that? As I sat here doing a little bit of research, and the best I could do is, I pretty quickly got confirmation that the only place in which unauthorized practice of law could be federally criminal is in federal enclaves where the law of a state are brought in, like a federal, like Fort Bragg in North Carolina, something like that. Are you aware of any other place where the unauthorized practice of law is rendered criminal by federal law?
You know, I have tremendous respect for our colleague, constitutional expert Jamie Raskin, who mentioned that he could provide some examples. But to answer your question, if I may have a couple.
Well, I'm going to reclaim my time unless you answer it quickly.
Well, I'm trying to answer your question, but the point of this.
No. Do you know whether there are any other occasions in
I'm happy to look,
right. I'll reclaim my time.
into it and provide you examples.
I think what Mr. Raskin said is that he thought that the unauthorized practice could be prosecuted as garden variety fraud, perhaps, but then you wouldn't need a specific law. This would be the only case that I know of in which the unauthorized practice of law is made federal and criminal. I'm not even clear that in North Carolina the unauthorized practice of law is criminal. It can be acted upon by the bar, but I couldn't find any crime. So the problem with this is not only that it moves federal law into an area it's never been in, but the question is for whom, and compared to other situations, what are you doing? So if someone is involved in a matter on federal court and they're victimized by someone practicing law without a license, if they're in bankruptcy court, if they're in a federal trademark matter, and on and on and on, in which you're having people dealing with federal law issues, if they are victimized by someone not practicing law without a license, then they're left to state.
Will you yield to a question?
I will not. They're left to their state authorities to enforce the law there. And so what that means is, for the sake, and the people who are victimized here are people, in many cases, illegal immigrants into the country. And so this bill would give priority to those people under federal law over every American who may be victimized by the unauthorized practice of law. And in the course of doing that, the majority is unwilling even to add Mr. Fitzgerald's amendment to say, if the same person's a member of the Mexican cartel, we want to punish him a little more. No, we can't do that. We're in an environment where prosecutorial resources have been so minimized for the sake of enforcing the federal immigration law that I think the figure is that customs enforcement officers, 6,000 of them are arresting an average of 2 a month or something if people need to be deported. It's been de-emphasized to the point of disregard of the law. And where is the one place where the majority sees it as a critical priority to federalize and criminalize the unauthorized practice of law? That is where notarios are victimizing predominantly illegal immigrants into the United States. That's what you want to do. That is amazing to me.
That's not true.
Well, I'd be glad to yield for an answer as to why that's not true, as long as it's a fast answer.
They are not predominantly undocumented immigrants. In fact, a lot of victims of notario fraud are American citizens. If you spoke to your constituents, you would know.
If you say so. I would submit that these people who are pursuing asylum claims that they will never prevail on, that's probably a lot of the people that you're talking about. But to the extent they are American citizens, then answer me that. And on your own time, why should they be prioritized over every other American in the way the law deals with them in matters of unauthorized practice of law? And with that, my time's expired.
Gentleman yields back. Who seeks recognition? A reporting quorum being present, the question is on the motion to report the bill H.R. 4435 favorably to the House. Those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported.
Yeas and nays, please.
Favorably to the House. Recorded vote has been requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson-Lee. Aye. Ms. Jackson-Lee votes aye. Mr. Cohen. Mr. Johnson of Georgia.
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch. Ms. Bass.
No.
Ms. Bass votes no. Mr. Jeffries.
Point of parliamentary inquiry.
The gentleman will state his point of
We're
parliamentary.
voting on final passage of the bill, correct?
Yes, we are voting on final passage of the bill. That is correct, sir.
Thank you.
Lofgren votes aye.
Ms. Lofgren votes aye. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Demmings. Ms. Demmings votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Ms. Scanlon votes aye. Ms. Garcia.
Yes.
Ms. Garcia votes yes. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush? Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat?
Yes.
Mr. Shabbat votes no. Mr. Gomert?
Yeah, but didn't vote no. I said pass. No. Right, no.
Sorry, Mr. Shabbat. Mr. Shabbat passes. Mr. Gomert? Mr. Isa?
No.
Mr. Isa votes no. Mr. Buck? Mr. Gates?
This isn't final passage, I think.
Mr. Gates?
No.
Mr. Gates votes no. Mr. Johnson of Louisiana?
No.
Mr. Johnson of Louisiana votes no. Mr. Biggs?
It was made.
Mr. Biggs votes no.
Good one. Is-
Mr.
it's never been a
McClintock?
product to pretend to be a
Mr.
lawyer.
McClintock votes no.
There's
Mr.
a separate
Stubbe?
problem, but why are we creating you know how easily you could slip into.
Mr. Tiffany? Mr. Tiffany
somebody
votes no.
thinking you're a lawyer when you're not. and be
Mr. Massey?
really
Mr. Massey
prosecuted.
votes no. Mr. Roy?
And, you know, and the witnesses against you will be undocumented aliens that you took money from.
Daryl, you on, buddy?
Daryl, mute your microphone, bud.
Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts?
Sparts, no.
Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz?
Mr. Benz votes no.
Mr. Benz votes no. Mr. Owens?
Owens, no.
Mr. Owens votes no.
Mr.
How am I
Deutsch?
recorded? Swalwell?
Mr. Deutsch?
Mr. Swalwell, you are not recorded.
I'll wait for Mr. Deutsch. Oh, sorry. Deutsch votes aye.
Mr. Deutsch
this is-
votes aye.
Mrs.
Bass,
Swallow?
how am I recorded?
Thank you. Swalwell votes aye.
Mr. Swalwell votes aye.
This is Bass, how am I recorded?
Ms. Bass, you recorded as no.
Please change that to aye.
Ms. Bass votes aye.
Shabbat, no.
Mr. Shabbat votes no.
Are there any members who have not voted, who who have not been recorded, who wish to be recorded?
Bush, Chairman. Bush votes no.
Ms. Bush votes no.
Are you, this is final passage, you know. Okay. The clerk will report.
Mr. Chairman, there are 20 ayes and 17 noes.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. And with that, the business of today, this concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.